All right, welcome everyone. Just as a note, if you're not yet speaking, if you could mute yourself so that any background noise does not get picked up, that would be great. I want to welcome everyone to tonight's judicial forum presented by the Junior League of Long Beach and the League of Women Voters Long Beach chapter. My name is Heather Brell, and I'm a part of the Junior League of Long Beach, the Advocacy and Outreach Committee. We would like to thank all the candidates and the attendees for joining us this evening. And at this point, I'm going to invite our league representatives to make some opening remarks.
Thank you. Hi, my name is Jane Bemis, and I'm the current president of the League of Women Voters Long Beach area. The League of Women Voters is a nonpartisan political organization which encourages informed and active participation in government and influences public policy through education and advocacy. We do not support or oppose any political candidate or any political party or any candidate. We do, however, take action on selected governmental issues in the public interest. We empower voters by working to educate our community on topics and policies that affect everyone.
Thank you, Jane. Now, Summer.
Oh, my name is Summer Smith, and I'm here on behalf of the Junior League of Long Beach as this year's co-chair of our Advocacy and Outreach Committee, as well as junior delegate for our California State Public Affairs Committee, also known as CalSPAC. The League has been the driving force behind initiatives and institutions that make our community a healthier, more vital place to live. Throughout its history, Junior League of Long Beach has developed, supported, and launched more than 60 projects into the community, making a measurable positive impact on the welfare of greater Long Beach children and their families. The League also focuses on advocacy and outreach in the community and often partners with the League of Women Voters to host candidate forums such as this. Welcome and thank you for joining us for our first hosted Judicial Candidates Forum.
Great, thank you, Summer. So before we begin, we have a couple of quick housekeeping items. Tonight's forum, including the breakout sessions, is being recorded and will be available for viewing in the coming weeks. The recording belongs to the League of Women Voters and cannot be used without written permission. No other recording of tonight's program is permitted. Pursuant to judicial ethics rules, judges and candidates for office of the judge of the Superior Court are not permitted to comment on cases that are before them or issues that they may need to rule on. So please keep that in mind throughout this program. With that, we will begin with candidate opening remarks. Each candidate will be given 1.5 minutes to speak. And during this introduction, they're going to introduce themselves, speak to you about their background and experience, and tell us why they want to be a judge on the Superior Court. We're going to do this in alphabetical order by last name, and we will start with Thomas D. Allison.
Good evening. 1 second. All right. Good evening. My name is Thomas Allison. I am running for judge because I believe we need more community in the courtroom. I have the privilege of serving as a volunteer temporary judge. My experiences with poverty, homelessness, hunger, and domestic violence provide me the insight to understand the burden that the people of Los Angeles County carry on a daily basis. I offer the most diverse legal experience of anyone in my seat, having conducted hundreds of hearings, court trials, and jury trials in family, criminal, civil, and landlord-tenant. I've also taught more than 60 courses in and around the law. This diverse legal experience means I have deep understanding of the law and the ability to communicate it with people who have no legal background. Finally, my studying public administration on a master's and doctoral level means I understand the root causes that drives many of our cases and can make better decisions that address the root cause rather than the symptoms that result in people staying in and out of court. Through my nonprofit, I have put on more than 80 free legal clinics, 100 community education programs, and I've served on 13 different boards of directors. My history of community service allows me to not only understand the people of Los Angeles County and the issues they face, but also the community-based solutions available to them. I am union endorsed and bring resources to the bench that no other candidate does. Thank you for your time, and I look forward to further engaging with you.
Thank you very much, Thomas. Now, next is Fernanda Maria Barreto.
Not sure if I'm up. Can you see me? Okay, great. Good evening. My name is Fernanda Maria Barreto, and I am a proud daughter of immigrant parents. I'm a native Angelino, a first-generation Latina, born and raised here in LA. I was born in Echo Park. My parents separated when I was 4 months old, and I was raised by my single mom as essentially an only child, even though I am my mother's youngest and my father's oldest. I to say my early beginnings was complicated is putting it lightly, but that's okay because it gives me one more thing in common with the people we serve, or I serve. And I think it's important to have something in common with the people we serve. It inspires trust and confidence in our judicial system. And that's one of the reasons I'm running. The Latinas on the bench are only 2%, even though the Latino population in California is 40%. We need a more diverse bench, and we need the bench to reflect the population. I've been a deputy district attorney for almost 16 years now, and the fact that I am fluent in Spanish has really helped me to be able to connect with the victims' families, even the defendants' families that I serve. It's given me the ability to help on a deeper level. I joined the DA's office so that I can help victims of domestic violence and sexual abuse specifically, because I would see that so much in the other careers that I had before I joined the office. Before I joined the office, I worked in medical clinics. I worked in a civil law firm. Thank you very much.
You're muted, Heather.
Sorry, I apologize. I muted myself. I said next up is Karen A. Barreto. Hopefully I'm pronouncing that correctly.
Hi, my name is Karen Bracco. I've been an attorney for over 30 years, the last 25 of which I've been a deputy district attorney. In my 30 years experience, one of the things I've noticed when I first started 30 years ago was that there were very few women on the bench. When I started in Orange County, my first job, the courthouse that I worked at had 2 female judges, and it was a rather large courthouse. And the second courthouse, or the first courthouse that I worked in as a deputy district attorney, it was a job, it was between 2 courthouses. In between the 2, there was only 1 female judge. And I'm running because I believe we need more females on the bench. Currently, the number of females is about 1/3 of the bench in Los Angeles County. In my current assignment, I'm assigned to the Long Beach branch. I am the special trials deputy, where I handle all of the high profile and complex murder cases from both Long Beach and the harbor area. Most days have been spent in the courtroom. I deal with victims and their families who have suffered unimaginable loss. I direct them to services to help them cope with the trauma that they've suffered, as well as educate them on what's going to happen as the case of their loved one goes through the system. I also handle the Catalina courthouse, where I handle low-level misdemeanors and spend most of my days there crafting unique solutions to a lot of the cases, because they're family involved, there's substance abuse involved, or mental health issues. And being on an island. I'm sorry? Okay.
Thank you so much, Karen. Next up is Renee Yolanda Chang.
Hi, good evening, everyone. My name is Renee Yolanda Chang, and I'm running for seat 70. A little bit about myself. I am married with 2 daughters, and I live in the South Bay. I'm the daughter of immigrants. I received my undergraduate degree from UC Berkeley and my law degree from Columbia Law School. When I graduated from law school, I knew I wanted to go into public service. And for me personally, I knew I wanted to help victims of crimes and to help work for public safety. So I joined the district attorney's office. And for the past 27 years, I've been at the district attorney's office doing all sorts of assignments, doing trials. I've been all over the county from Long Beach to East LA, from Compton to Airport Courthouse. Currently, I'm working in the South Bay. I've realized through the course of my career that our victims who don't often have money, who are undocumented and very vulnerable, need help to guide them through the court system. And I've been proud to do that for 27 years, especially these days when victims feel like they're being forgotten. I'm currently the deputy in charge, which is a supervising deputy of a unit that prosecutes child molestation, sexual assault, domestic violence, hate crimes, and elder abuse. I'm running not as someone with a political agenda, but someone who has the most experience, who is the most qualified and the highest rated in my seat. I've been rated well qualified by the Los Angeles County Bar Association, while my opponents in my seat have been rated not qualified and qualified. So I am asking for your support. Thank you very much.
Thank you very much, Renee. Next up is Bryan Dibble.
Thank you and good evening to everybody. Glad to speak with you today. My name is Bryan Dibble, running for seat 67. I am a 16-year veteran of the Deputy DA, the District Attorney's Office, proud of my public service there. I've served in special units in the District Attorney's Office, including Major Narcotics Division and the Hardcore Gang Division. I currently am assigned to Long Beach as a violent crimes and homicide prosecutor. I am running to become a judge who has a good judicial demeanor and is a public servant who will treat people with respect and give everyone their day in court. I feel like I'm an intellectually curious person who will listen to both sides and learn about people while making an informed decision. I view myself as an ethical prosecutor who, when sitting in criminal court as a bench officer, will have high expectations of the ethics of prosecutors while listening to and respecting the rights of the accused as well as the rights of victims and witnesses to be heard. I have a broad range of endorsements, including from the Torrance Democrats, victim groups, law enforcement, and the Metropolitan News Enterprise. And I've also been rated well qualified by the LA County Bar Association. And what this says, I think, is that multiple groups of people from different walks of life have determined that I would be a fair judge. Thank you for your support.
Thank you, Ryan. And next up is Carol Elswick.
Good evening. My name is Judge Carol Elswick for seat number 156. I am running because my seat has been challenged. I have 30 years of judicial experience, including 22 years as a Los Angeles Superior Court judge. I presided over an estimated 60,000 cases during that 30 years. That is 60,000 cases. I've been a site judge for at the West Covina Courthouse, where I supervised 10 judges, commissioners during that period of time. I presided over felony trials and preliminary hearings, which included murder, attempted murder, assault with a deadly weapon, rape, robbery, child molestation cases. I presided over civil cases and civil trials. I've been a supervising judge of the small claims and traffic departments. Prior to being a judge, I was municipal court commissioner for 6 years. Before taking the bench, I was a civil litigator and also a prosecutor for the Los Angeles City Attorney's Office, where I prosecuted felony robbery cases and misdemeanor cases. Before taking the bench, as I said, I was a civil litigator. I have been rated qualified by the LA County Bar Association. My opponent was rated not qualified. I look forward to your questions and thank you very much.
Thank you very much, Your Honor. Next up is Randy Fudge.
Hello, I'm Randy Fudge. I am currently the Assistant City Prosecutor for the City of Long Beach. That's the number two person in the office. The Long Beach City Prosecutor prosecutes all adult misdemeanors in Long Beach and is the third largest prosecuting agency in the county. We are also a nationwide leader in offering defendants alternate sentencing, including drug and mental health treatment, housing, and job assistance in lieu of prosecution and/or fines. I feel I'm the most qualified person running for judicial office. I have been practicing for approximately 29 years. Unlike other candidates, I have amassed significant experience in both civil and criminal worlds. As a civil litigator, I have practiced in both state and federal courts in a wide variety of areas, from premises liability to civil rights to constitutional law. I've taken multiple cases to trial. I handled multiple appeals in the California Court of Appeal, the United States Court of Appeal for the Ninth Circuit, and the United States Supreme Court. As a criminal prosecutor, I've conducted multiple jury trials, hundreds of court trials, and oversaw over 70 criminal appeals, in addition to training, lecturing, and handling complex cases. However, our office is not all about prosecution and incarceration. Indeed, there are often factors that show that criminal prosecution is not warranted, and our office will always take those into consideration. Although cliche, I want to do justice. Criminally, sometimes that requires prosecution, sometimes it requires a helping hand. I want to be a judge that will take the ability and experience and temperament to be a judge. I've seen good judges that I would like to emulate. I've also seen some bad judges and feel I can do better. At the end of the day, I'd like to give back to society by being even-handed and leading by example.
Your time is up.
Thank you, Randy.
Thank you.
Next up is Leslie Gutierrez.
Hi, everyone. I'm going to keep it short because I have a cold, but my name is Leslie Gutierrez. I'm running for seat 90. For the last decade, I've been a prosecutor with the District Attorney's Office. I've been serving our community. Before that, I was a defense attorney. I have a bachelor's degree and a master's degree in economics, and I graduated from Southwestern Law School in the top 1% of my class. I'm originally from France. I moved to the United States when I was 22 years old on my own. I'm currently in a unit in the District Attorney's Office that focuses on the prosecution of child molestation, child murder, sex crime, and elder abuse. I've tried many cases, anything ranging from misdemeanor to murder. I want to be a judge because I also, like Randy, want to serve and help the community, and I want to do justice. I've been in court every day for the last decade. I've been able to observe the criminal justice system at work. I know what works and I know what needs improvement. I also noticed that there aren't many women on the bench, like it's been stated earlier by another candidate. And I do think that we need more women on the bench to be able to serve the entire community better. I've been endorsed by judges, by unions. I've been endorsed by attorneys who trust and believe that I am a fair and ethical prosecutor, and I'm asking for your vote. Thank you.
Thank you, Leslie. Next up is Melissa Hammond.
Good evening, everybody. My name is Melissa Hammond. I'm born and raised in Los Angeles. My grandparents are Holocaust survivors who came to Los Angeles to make a new life for themselves after the Nazis murdered their families with machine guns and gas chambers. My grandparents taught me the importance of family and seeking justice. This desire for justice ultimately led me to a career with the District Attorney's Office, where I work today. I'm running for judge because it is my calling, and it always has been. I'm excited that the time is finally here to see it through. This calling has evolved from a childhood dream into a passion to help my community. I believe I'll be a good judge because I'm fair, compassionate, and experienced. My legal experience is well-rounded. My first job in law was actually working for my dad, who's an LA-based criminal defense attorney, and helping him with his clients and cases. Then, during my time at UCLA School of Law, I conducted administrative hearings in front of administrative judges. After graduating from law school, I worked for a civil law firm, followed by the public defender's office in LA. Then I went to the district attorney's office. I'm the only person in the whole race who has been a public defender and a DA and has that rare perspective. I have done trials and hearings as a public defender, district attorney, and as a civil litigator. I've been rated well qualified by the Los Angeles County Bar Association. I'm the only woman in my seat currently practicing in the Superior Court and serving the public. I'm also a mother, which is honestly the greatest job of all. If I get elected, I want to work primarily with children in dependency or juvenile court. I'm really honored to be here with you all tonight. Thank you for having me.
Thank you very much, Melissa. Next up is Holly L. Hancock.
Good evening, everyone. Again, my name is Holly Hancock, and I'm running for Los Angeles Superior Court, seat number 70. I thank you for your attention. I'm running to give the voters a choice. I believe that my professional background and the way that I practice differentiates me from my prosecutor colleagues. I am a deputy public defender. For the past 16 years, I have fought for people's constitutional rights in the criminal court system, and that is not an easy position to operate from. I have tried during that time 65 trials to jury verdict in 14 years, and I have won or had reductions in about 80% of them. On a daily basis, the case trajectory is much less extreme. I must look at the effect on the client for any plea agreements that I give and their families. Generationally, they are all suffering. The effect on the victims and their families generationally. I have to know both sides of the case. For this reason, I practice long-term solution building for both the client and the community. That is how we make the community safe. I have to get to the root cause of the problem. Public defenders do the heavy lifting. We appoint the psychologist, we petition the court for mental health diversion, we ask that the client be moved to specialty courts such as victims of human trafficking and homeless court, of which there are only 2, and Long Beach hosts one of them. For the past 2 years, I have worked in post-conviction. I am a supervisor or the deputy in charge of the Criminal Records Clearing Division of the county's homelessness initiative. And I run the much beloved Homeless Mobile Unit.
Your time
so
is
we do
up.
stand. Oh, thank you. Thank you very much.
Thank you, Holly. Next up is Lloyd Handler.
Good evening. My name is Lloyd Handler. I'm currently working as a deputy public defender at the Criminal Courts Building downtown. I'd like to thank you for organizing this forum, and I'd like to specifically thank Heather, who I think I've seen in court almost every day for the last 2 weeks while she's been trying to herd all of us lawyers. Getting lawyers organized is referred to as herding cats, and she's done an amazing job. Anyway, a little bit about myself. I have a Bachelor's of Science degree from the University of California at Davis, and also went to the UCLA School of Law. After law school, I clerked at the U.S. District Court downtown and had a chance to see how judges go about the act of judging in terms of how they think about cases and write opinions. I then went to the district attorney's office for a while. And as a DA, I've had a chance to handle attempted murder cases, domestic violence cases, spousal rape cases, other sexual assault cases. And in addition to putting on those cases, I had a chance to learn how they affect the victims directly. I, however, became disillusioned with the DA's office for a number of reasons based on the DA in charge at that time, and joined the public defender's office after having been recruited by some of the lawyers I was litigating against. I've been a public defender for most of my career, although before we were married, when my wife took a job in the Bay Area, I moved up there and was in private practice for 4 years. So I also have had experience as a private lawyer and understand the pressures that lawyers have when they're running a small private practice. However, I have been a career public defender, and overall, I've been a trial lawyer in the criminal justice system for 33 years.
Your
I have
time
more
is up.
trial. Thank you.
Thank you, Lloyd. Next up is Patrick Hare.
Good evening. My name is Patrick Hare, and I'm a candidate for judge in seat number 151, and I am a public defender. I'm running for judge for the same reasons that led me to become an attorney over 32 years ago, and that is my deep commitment that justice matters. And when I say justice, I mean the sort of justice that restores our communities to wholeness. For victims, absolutely, but also for those accused of crimes. I've been an attorney for over 32 years. I've practiced civil as well as criminal. I've done dependency cases, conservatorship cases, and criminal cases ranging from trespassing all the way to special circumstance murder cases. I've also spent much of my career in the collaborative courts, focusing on treatment over incarceration. I've been honored to receive a rating of well qualified from the Los Angeles County Bar, the only candidate in my race to receive that. I've been extensively involved in community service outside of the office, and based on my work and my work outside the office, I've seen the effect that crime has on our communities, but also the transformative effect that housing and education and treatment have on our communities, providing true community safety. I'm grateful to have the opportunity to address you, and I look forward to the opportunity to earn your support. Thank you.
Thank you very much, Patrick. Next up is Georgia Huerta.
Hello. I'm having computer problems, so can everyone hear me?
Yes, we can.
Okay, thank you. Again, my name is Georgia Huerta, and I am running for Superior Court Judge, seat 118. My beginnings is a little bit different. I left the district attorney's office last year after serving there for 30 years. However, when I left the district attorney's office, I did not leave my knowledge there or my desire to serve the public. And the reason why I have such a strong desire to serve the public is that I grew up on 104th and Broadway in South Central Los Angeles with my mother and 6 other siblings. And I got to see the criminal justice system maybe not operating at its best. And as a result of that, I decided to become an attorney, a deputy district attorney. And I felt by being a deputy district attorney, I could truly serve the people in my community, because in many, many instances, it's the people in my community that ended up in court. I'll let you know that I attended local Los Angeles Unified School Districts. I graduated from Manual Arts Senior High School, went to UCLA, USC, and I got my master's degree from Western State University of Law. When I say that my calling was to be a deputy district attorney, I was fortunate enough to be hired as one. I served there for 30 years inside of a courtroom each and every day. I tried over 80 jury trials, from regular misdemeanors to special circumstance. Not only did I, thank you.
Thank you, Georgia. Next up was supposed to be Nasser Khoury. I have not seen him log on. Nasser, are you there? Okay, not hearing him respond. And next up would be Keith Quijano.
Good evening, everyone. I'm Keith Quijano, and I'm running for seat 118. I am running to bring integrity, diversity, and compassion to the bench. These are characteristics and qualities that I have instilled in myself over 16 years of being a deputy district attorney. I am the most experienced homicide prosecutor in this particular race. I have tried over 12 murder cases to verdict, and what that has ultimately taught me is how to communicate with people who are facing the most dire circumstances, whether they are victims, family members, whether they are defense attorneys who are upholding the constitutional rights of accused defendants, or they are people who are charged with crimes but are necessary witnesses for these cases, and people who are subject to leniency and immunity agreements. Ultimately, this experience taught me how to deal with people in a respectful way. These are the same skills that I earned through working in South Central Los Angeles, Watts, Compton, and Inglewood. I am the only candidate who is endorsed by both large law enforcement as well as labor organizations, and that's because I understand how to treat people with respect, which is what's most important in a judge who oversees the people of Los Angeles County. Thank you so much for having me this evening, and I hope I earn your support.
Thank you, Keith. Next up is Elizabeth Lashley Haynes.
Thank you so much. Good evening, and thank you to the Junior League of Long Beach and the League of Women Voters. It's an honor to be here. I'm Elizabeth, and I am a deputy public defender. I'm running for seat 67. In addition to a public defender, I'm also a mom. I'm a lifelong Democrat. I'm a union member. I'm public school educated. I serve on the governing board of my church, and I'm the president of the Women Defenders Association. My husband and I are originally from the Midwest. We had a brief stint in New York City before we drove out to LA 20 years ago, where we built our lives and we happily call LA our home. As a public defender for nearly 2 decades, I'm in the courtroom almost every day. I've tried the small cases all the way up to the big murders. Before coming to the public defender's office in law school, I had the honor of clerking for a federal judge in the Second Circuit Court of Appeals in New York. I've had a variety of experiences within the public defender's office. I've supervised newer attorneys. I've been in the I was a juvenile resource attorney where I worked outside of the courtroom, advocating for children who are involved in the justice system and getting them special education and regional center services. Currently, I practice in family law court, and I also litigate the Racial Justice Act, which is a new law that seeks to redress bias and racial prejudice in our legal system. The reason I'm running for judge is because after those 2 decades in court, I reached a point where I just saw that the legal system is not working as it was intended, and it's not living up to our democratic ideals.
Your time
Most
is up.
everyone, thank you so much. I appreciate it.
Thank you so much, Elizabeth. Next up is Melissa Lyons.
Good evening, everyone. Melissa Lyons running for seat 90, and I am running to be a part of the decision-making process. As an immigrant, I understand the importance of a decision and how long-lasting it can be. Someone's decision so many years ago to allow my parents to come here to work is exactly what has allowed me to sit here before you today, asking for your support and to run as a judicial officer. However, in my career, I have seen bad decisions affect victims as well as defendants alike negatively. And so I'm running because I think that we can assist the system in becoming better by bringing more diversity to the bench. For me, diversity is not just about me being Black or me being a woman or me being an immigrant. It's also about the work that I do from 5 to 9. From 9 to 5, I'm a prosecutor. I work for the last 16 years in the DA's office. Currently, I am the supervising deputy district attorney for the Compton Juvenile Division. Prior to that, I spent about 1/3 of my career in the sex crimes division prosecuting cases of sexual assault against child and adult victims. I have over 85 trials, over 68 of those are felony trials, complex litigation trials. And outside of the office, I have been a volunteer for the Summer Night Lights program, which is put on by the Gang Reduction and Youth Development Office. I have also been a volunteer for Project LEAD, which teaches 5th graders about the criminal justice system.
Your time is up.
Thank you. I hope to earn your support.
Thank you, Melissa. Next up is Kevin Thomas McGurk.
Kevin, you're muted.
Can you hear me now? Okay.
Yes, now we can
Hi,
hear you.
thank you. My name is Kevin McGurk. I apologize for the venue. My daughter's in the Jungle Book. There's no green room here, so I'm just going to sort of in the corner. I've been with the Public Defender's Office for 17 years. The goal of this campaign, at least for me, is to try to blend the requisite and the right experience. I live in Long Beach. My wife, who's also a public defender, she does juvenile resource. I have 2 daughters, as I mentioned, 6 and 2. And during the 17 years I've been a public defender, I've been in court almost every day. For 13 of the last 14 years, I've done felony trials. I've got 50 open ones right now. I'll be in court tomorrow morning, multiple homicides. The last 10 trials I did were serious or violent. Last 2 were murders. What you're getting with me is someone who does serious, complex cases, serious homicides. It's not just courtroom experience, but it's the quality of that experience lends itself to more complex issues that will come up in terms of being on the bench. I've been rated well qualified by the LA Bar Association, which is primarily based on temperament, experience, and integrity, 3 things that form the backbone of a good bench officer. That's the requisite experience. The right experience is bringing diversity of perspective. Last 10 years, 43 open seats have gone to the voters, 90% to prosecutors, 0 to defense lawyers. And that's at a time when we are rapidly changing into more sentencing alternatives, such as structured programs, where the defense coordinates all that, psychologists, treatment specialists. We know what programs work and which
Your
programs
time
do
is
not.
up.
Thank you.
Thank you, Kevin. Next up is Clint Mckay.
Thank you. I am running in seat 118. I left home when I was 15 years old. I put myself then through the rest of high school, through undergraduate work at the University of Michigan, where I graduated with honors. And I was the first male to graduate with a degree in women's studies, as well as psychology. I then put myself through law school, then an MBA at the University of California at Berkeley. I then practiced law for 25 years approximately. I tried my first case in 1978, which is a while ago now. I then became a deputy attorney general with the Attorney General's office. In that capacity, I specialized in prosecuting doctors who killed children, who were mentally ill, and who dealt drugs. I then became an administrative law judge. I was a line judge for 7 years, over 7 years. I tried all of the cases involving covered California and in the county of Los Angeles and lower income Medi-Cal recipients and foster care cases. Last year, I was elevated to presiding judge. I now supervise a panel of judges and I train them how to be better judges. I review every single decision in the state of California in those areas that they release. I also am endorsed by the Democratic Party of the San Fernando Valley, a number of other different endorsements, and thank you very much. I appreciate the opportunity.
Thank you very much, Clint. Next up is Carolyn Park.
Hello, thank you so much for having me. I'm running for seat 118. I'm running because as a community lawyer, I bring a perspective that will allow me to run as fair a courtroom as possible. The LA Superior Court judges make decisions which affect so many aspects of our lives, whether it's civil, criminal, family, juvenile, small claims, traffic, probate, mental health, or appellate courts. The current salient legal issues highlight the need to restore trust in the judiciary. A more just justice system requires far more diversity on the bench. We need more women of color, and most importantly, we need more judges with experience as community lawyers, not more prosecutors or corporate defense attorneys who comprise the majority of the bench. That's why I'm endorsed by the founder of A New Way of Life, Susan Burton, Unite Here Local 1000, Assemblyman Isaac Bryan, Assemblyman Ash Kalra, and so many more. I was born and raised in Los Angeles. I've been a practicing attorney for over 18 years, and a third of my career was spent at a public sector union representing about 9,000 state workers throughout LA County in administrative hearings and in civil court. I've litigated approximately 60 cases and settled many more. I've also represented immigrants, people exercising their constitutional rights and tenets. I'm currently handling a lawsuit against the Sheriff's Department over civil rights violations that occurred during the 2020 protests.
Your time is up.
Thank you, Carolyn. Next up is Sharon Ransom.
Good evening. Thank you for having me. I'm Sharon Ransom and I'm running in seat 60. I'm running for judge because I have a passion for justice and equality, and I'm passionate about the fair treatment of everyone that comes into the criminal justice system. I'm also running because out of nearly 600 judges in Los Angeles County, less than 5% are Black women, and we do need more diversity on the bench. My background is a little bit different. I was born and raised in South Central Los Angeles. I was raised by a single mom. I went to LAUSD public schools. I became a single mom myself at the age of 21. I put myself through school at night while raising my daughter and being a dispatcher for the Sheriff's Department for 17 years. I've currently been a deputy district attorney for 17 years, currently assigned to the mental health unit. Prior to that, I was in the victim impact program, elder abuse, major narcotics. I'm very involved in community service. I also teach Project Lead to 5th graders. I'm involved in teen court as well. In our office, I also conduct recruitment. I'm part of the recruitment team to bring in diversity to the district attorney's office. I've done parole hearings. I've done search warrant duty. So I have a breadth of experience, legal and life experience, that qualify me to be a great judge. I believe that we need judges that come from all walks of life, not just singled out to a certain profession, too many DAs, too many public defenders, but people that are really committed to the community, committed to making a difference, committed to treating everybody fairly with respect, and just being a fair person and unbiased. And I hope I've been rated well qualified. I hope to seek your support. Thank you.
Thank you very much, Sharon. Next up is Anna Slotki Ratano.
Hi, I'm Anna Slotki Ratano. I'm running for seat 60. I'm a wife, a mother of 2 awesome kids in elementary school. I'm endorsed by more organizations than any other candidate in my race, including the Democratic Party of the San Fernando Valley and Ground Game LA, as well as judges, attorneys, and doctors who work in mental health cases with me. I have prior experience as a clerk at the DA's office, working in labor and administrative and civil cases, but I was drawn to making sure that there was equity in the law. So for almost a decade, I've been a trial attorney at the public defender's office. I have experience with everything from misdemeanors to murder. For 3 years, I represented children in the juvenile system, and I love that. I'm running for LA County Superior Court Judge to bring balance to the bench for the benefit of all of the residents of LA County. I wanted to offer a viable alternative to the standard judicial fare. Unlike the other candidates running for this seat who are prosecutors, I am a public defender, and that sets me apart because of the perspective that a public defender brings to the courtroom, as well as the work ethic. A public defender has never been elected for judge, and I want to change that. I have a unique perspective because I chose a career working with the poor and the mentally ill and the least powerful people in the courts. That perspective should be represented on the bench. My work isn't just limited to trials, although I have done a lot. I find solutions through knowing the issues in the communities, the people I work with, and the law. As a public defender, I work to do better by appointing social workers, finding housing, treatment programs, and mental health care. Thank you.
Thank you very much, Anna. Next up is Tim Rubin.
Hello, my name is Tim Rubin, and I am running for office number 3. Now, importantly, I want you all to know that Judge Garnett, who currently holds office number 3 and is on the ballot, has been appointed to the federal district court and is in fact going on the federal court next month when she is sworn in. So she is not pursuing this office anymore. I, on the other hand, have been rated well qualified by the bar. I graduated from Harvard Law School in 1980 and have practiced in LA County continuously ever since. I've tried cases all over LA County, and I've practiced for over 40 years. 30 years ago, I formed my own law firm, and I've managed it and trained young lawyers and handled every kind of case. I've tried criminal cases as a prosecutor and as a defense lawyer, tried divorce cases, probate cases, wills, trust, personal injury cases, every manner of civil action, employment, real estate, construction, insurance, entertainment, banking, securities. I am a student of the law, and I've published over 50 legal articles as well. And I am endorsed by the LA County Democratic Party, the Metropolitan News, and many other organizations and judges. I ask for your vote. Thank you very much.
Thank you very much, Tim. Next up is Albert Robles.
Yes. Good afternoon, everyone. I'm happy to be with you. I've been a practicing attorney for over 20 years, and my legal experience includes also being a professor at a community college, Rio Hondo Community College, where I taught business law to students for a couple of years. I've also been a guest lecturer at Cal State Dominguez Hills. In terms of my public service, I've served for about 30 years now, both on the Water Replenishment District and on the council in the city of Carson. Every forum that we have, every judicial candidate always says that they're running to bring respect to the courtroom. They're going to treat everybody fairly, that they're going to respect everyone's rights. Well, there's one person, the person that I am running against, who has been publicly admonished for violating the fundamental rights of defendants, for showing bias in the courtroom, for abusing her judicial authority, and for violating the code of judicial conduct. Only one candidate, and that is my opponent. So the choice is her, who has been publicly admonished after a comprehensive investigation that included reviewing transcripts that were submitted under penalty of perjury, and a hearing where she was given a full opportunity to represent herself with her legal counsel to try to clarify the record. And she was found to have misled, if you will, or flat out lied to
Your time
the
is up.
Judicial Council. Thank you.
Thank you, Albert. Next up is Troy Slaton.
Good evening, everyone. My name is Troy Slaton. I'm running in Office 60. I'm currently an administrative law judge assigned to the State Building in Van Nuys, California. I'm born and raised here in Los Angeles County. I've lived here my entire life. I'm a husband and father of two public school kids. I'm a product of the public schools. I started working at age 5 years old. I was on some TV shows in the 80s and 90s. And I tell you that because instead of going the path of so many of my contemporaries down the wrong path, luckily I had some good guidance. And I was able to put myself through college, UCLA, law school at Pepperdine, and my brother through medical school. I started working in the court system about 6 years ago. And I was assigned a judge pro tem for the Los Angeles County Superior Court, where I served dozens of times. I've appeared before hundreds of judges as a defense attorney on the prosecution side, in civil court, administrative court. And I've seen so many great judges and so many awful judges. And the thing that I saw about all the great judges is that no matter if I won or lost, it's the ones who really gave me an opportunity to be heard and were prepared. And whether or not I won or lost, I felt like they really gave me a fair shot. And if I got that, then I really felt satisfied. So as a judge,
Time is up.
Thank you so much.
Thank you, Troy. Last but not least is Matthew Vadenoy.
Thank you. Hi, Matthew Vadenoy. I am running for judicial seat number 70. Thank you for having me this evening. I'd like to share a little bit about myself. I was born and raised here in Los Angeles, the child of a criminal defense attorney. My dad practiced for more than 50 years here. After I graduated law school, I went to the private sector, where I worked in the workers' compensation defense world, as well as worked in workers' compensation for plaintiffs for a period of time until I was hired as a deputy DA. I worked as a deputy district attorney for more than 14 years, trying every kind of case everybody here will have said they've tried. And I think what happened for me that is extremely different from everybody else, and this is no discredit to anybody that works for the DA's office, is that I decided to leave because it just wasn't a fit for me. And it was time for me to try and expand myself and my knowledge base. I became a defense attorney in 2019, and that's what I do to this day. I stand next to the people that are wrongfully charged and people that are overcharged and people that are properly charged, to be fair and honest. I do all the same things my competitors do. But the thing that distinguishes me, and what all of you should pay attention to, is not what you do for a job, not where you grew up, the color of your skin, your gender. None of those things make you or qualify you. What does qualify you is who you are and what you bring to that bench, and how you are distinguished. Are you going to be a good judge because of the person you are? I'm a father, I'm an attorney, and I'm a human, and that's what I will bring with me. Thank you.
Thank you very much, Matthew. Now we will move to our topic breakout rooms. Each room will have a moderator to help track time, and each candidate will have 4 to 4.5 minutes to deliver their remarks on the topic, and that's dependent on how many panelists are in each room. Hello, everybody. My name is Heather Brell, and I am the event coordinator for the Advocacy and Outreach Committee within the Junior League of Long Beach. I will be your moderator for this session on the role of the Superior Court, which is appearing on your screen now. Shared with you today are the prompting questions that each candidate may choose to address during their remarks. Each candidate will have 4.5 minutes to speak, and the order of each speaker has been randomly assigned. If anyone watching has any questions they would like to ask, time permitting, please submit them to me in the chat box. This breakout session will be 30 minutes long, is being recorded, and will be posted on the League of Women Voters website for public viewing. At the end of the 30 minutes, all participants will be brought back to the primary room where we will hear some closing remarks. The prompting questions addressed in this session are on the role of the Superior Court. What are your specific connections or experiences with the Superior Court and how it operates? What strategies do you use to maintain objectivity? What would you do if the law required you to make a decision that was against your opinion or personal beliefs? And what would you explain to younger voters about why they should be specifically interested in who sits on the Superior Court? I believe first up was Fernanda Barreto, so you may begin.
Thank you. Again, my name is Fernanda Maria Barreto, and I have been a deputy district attorney for the past 16 years. So I always tell people that the courtroom is my office. I'm there almost every day, and I have become very intimately aware of how the courtroom works, how the attorneys function in the courtroom, and how everything works together. Sorry, the screen disappeared, so now I can't see. I'm working off of my phone, so I apologize. I'm sure there's nothing you can do about that, Heather. Oh, thank you. So how the court operates, I am extremely familiar with how it operates and how trials work, how the day-to-day function works, how what we call a calendar works, how we call how we call each case. And the strategies I use to maintain objectivity is when I'm reading a case to consider it to be whether or not charges should be filed, because that's one of the things I do. I try not to read the name of the person who is being accused of a crime, because sometimes that will give away gender, race. So I try to not look at that first. I also will step back and ask myself, if this were a different, once I do know, if this were a different gender or a different race, would I treat this person the same way? I do that when filing charges, when thinking about dispositions on cases. I always try to look at it from different sides. I also do that when I'm trying a case, try to look at it from all sides to make sure that I understand the case from every facet or every viewpoint. What would I do if the law required me to make a decision that was against my personal beliefs or my opinion? I would have to make that decision, because we as judges are not there to impose our personal beliefs or impose our personal opinions. We are there to apply the law. We are there to apply the law equally in all cases. We are there, we can interpret the law, but we're not there to make law or change law. And so even if I may not like the decision I have to make, that's part and parcel of the job. And what would I explain to young voters about why they should be interested about who sits on the Superior Court? Well, who sits as judges is very important, as we've seen in current events. But on the Superior Court, the person who's interpreting that a individual's case will decide what kind of, on a lesser case, on a case that, let's say, is not a life case, can decide whether or not this person deserves probation, whether or not this person should go into programs, what kind of rehabilitation this person should have. And it's that ideology or that thought process that can make a difference in a person's life. If a judge only believes in punishment, then they're not going to have the same impact on the community as a judge who believes and wants to focus on rehabilitation. So that is why everyone, not just young voters, but everyone should care about who sits on the Superior Court. And it's not just criminal cases, but also civil cases, family law cases. These are all Superior Court cases, and it's all the judicial candidates. We don't get to pick where we end up on our assignment. So we can end up in any of these courts. So these thought processes can go into any of them. So that's why it's important that we understand who will be filling these vacancies. I'm not sure how much time I have left, if any.
You have 9 seconds left. So
So thank you very much.
thank you very much, Fernanda. Next up is Melissa Hammond. And Melissa, would you like?
Can I say one more thing?
Yeah.
I'm sorry. My phone is about to run out of battery, so I do have to go, and I apologize that I won't be here for questions.
Thank you. Melissa, would you like me to have the slide remain up, or do you want me to stop the screen share?
Yeah, I don't need it up. I'm familiar with what it's asking.
Thank you. You may proceed.
Okay. So hello again. Again, my name is Melissa Hammond. I'm running for office 118. I was basically born into the Superior Court. I've been going to court with my dad, a criminal defense attorney, since I was about 5, 6 years old. Other kids went to playgrounds, and I went to the courts and jails in Los Angeles to talk to my dad's clients. I've been working in the Los Angeles Superior Court myself for almost 20 years now. My experience has been in civil litigation, as well as criminal prosecution and criminal defense as a public defender. I've been in public service for over 17 years. I practiced in almost every Superior Court in Los Angeles at one point in time, and I'm endorsed by over 60 Superior Court judges and bench officers. I tell you this because I really want all of you to feel comfortable, to know that I am very experienced in the Superior Court, and I'm excited to take this next step to become a judge. I know it can be fair since I've done hearings and trials on both sides of the courtroom. I understand the perspectives of the accused, of their families, the victims and their families, and the witnesses in a case. I also understand the perspective of plaintiffs and defendants in civil litigation. This perspective helps me maintain objectivity in the court. When a defendant is brought out in court before me now as a DA, I know what has gone on in lockup just before that, what the general discussions with the attorneys might have been, having talked to hundreds, if not thousands, of people accused of crimes in lockup myself. Until you have done both sides in criminal and civil, you really have no way of truly understanding that perspective. I'm going to tell you quite honestly that I'm very well balanced. I do not have strong personal beliefs or political views, which is why I know that I can be very fair to all sides. I believe that all people accused of crime should be treated fairly, that victims should be heard, and that their families should be well informed about the case. I always try to explain things in a simple manner to victims and their families so that everyone can understand what's going on. I also explained issues in simple manners to my clients when I was a public defender and their families. Now is a very interesting and significant time in the courts, as I'm sure you're all aware. As I stated earlier, I am one of the only people in my particular seat in 118 who actually practices in the LA Superior Court. I am the only woman in seat 118 who currently practices in the Los Angeles Superior Court. And I'm the only woman in seat 118 who currently serves the public. This is important, especially given what's going on right now with women. We need more women judges. Only a third of judges are women, which is not in line with the proper ratio of women to men. As you know, we also need people who are currently familiar with the Superior Court, not people who worked there once upon a time. In the past year, there has been so much change in the court, with new legislation from the governor regarding enhancements, aggravating factors in sentencing, resentencing, and more. There are also new directives in the last year issued by the district attorney. Almost every day, I am reading a new law or new directive that has come down in my email and trying to understand it. Someone who has not practiced in the Los Angeles Superior Court for years, or even in the last year, would have no knowledge of the overwhelming amount of new legislation that has been passed. So as to younger voters, they really need to know that more women and people who are familiar with the current state of the Superior Court and what's going on in the Superior Court every day should be the ones sitting as judges. It is extremely, extremely important to make sure the Superior Court is composed of experienced, intelligent, and strong women like myself. I am also ready to take on this role in the prime of my career, having lots of energy and enthusiasm to learn new areas of law. I also really want to work with children. I would love to work in juvenile, which is where I've worked in juvenile before, or dependency court, which I've worked in a little bit. And I believe that you can really make such an impact on youth. And having 3 children of my own, I understand children very well. My kids are fairly young, and I really feel like I can make an impact on those kids and try to stop the cycle of kids repeating the same mistakes as their parents and not having proper role models. I really feel that I can make an impact in the juvenile justice system. So based on all of that, I know that I have some time left, so I would love to answer any questions that you may have about anything I've said. And I'm really thrilled to be here with all of you. Thank you.
Thank you, Melissa. Next up is Albert Robles.
Thank you. Martin Luther King had a quote that said, a threat to, or injustice anywhere is a threat to justice everywhere. And I believe that. As we say, younger voter, I'm assuming 18, 19, you don't think about that too much. But the fact of the matter is, young people have an incredible equalizer when it comes to elections. Young people generally don't have a great wealth of experience, don't have many resources, maybe aren't, without due respect, aren't as smart as they will be and will become. But the one thing that they have that is equal to everybody, regardless of their socioeconomic status, regardless of their age, regardless of where they live, regardless of their background, their ethnicity, is the right to vote. And that right to vote is equal to everyone. So if you're 18, you need to vote. You need to tell all your friends to vote. And who you vote for judge matters. Absolutely matters. May not matter for you. I hope that young people never have to go before the court, other than an attorney, of course, or jury duty, but not as a party. But a friend of yours or a family member may have to go before a judge. And it's imperative that when that person goes before the judge, that they are treated fairly, without bias, with due respect to all their fundamental rights. And there is situations, as was said by another candidate, where there are good judges and bad judges. And the bad judges need to be replaced. And your participation in our judicial process and in your opportunity to vote in this upcoming election is absolutely critical. I've been an attorney for 20 years, and I've been in courtrooms throughout the state, throughout LA County, both federal and Superior Court, the Court of Appeals, and I've seen it. There are good judges and there are not so good judges. And sometimes you wish you didn't have the judge that's before you, but sometimes we just have to deal with it. And you, as young people, have an incredible opportunity to make your voices loud and clear. One, by voting, but two, by voting for your preferred judicial candidate, a person that's going to respect your fundamental rights as an individual, one that's not going to be biased, not only against you, but against anybody, and that's going to abide by the rules of judicial conduct and not be questioned as to whether or not they're abusing their authority. It's imperative for the integrity of our judicial system that judges act accordingly and judge fairly and objectively. And it's difficult when we see that not happening, and for us to continue to believe in the system. I understand that. I believe in our judicial system. I think it is the best in the world, but it's not perfect. It needs improvement. And that improvement only comes from the participation of younger individuals to make their voices heard. And the best opportunity you have to make a loud statement is during the election process and voting for the judge who is best educated, best experienced, and best committed, as proven by 30-year record of public service, to be objective, to listen to both sides of a situation before making a ruling or arriving at a decision. That's absolutely critical. And I think that there is incredible opportunity for young people to get involved. One of the things that I hope to do if elected as a judge is to take just that opportunity and make myself available to younger people. As a professor at Rio Hondo Community College teaching business law,
Albert, your time is
I've
up, so if you
mentored
can wrap it up,
individuals.
that would be great.
Thank you.
Oh, okay, thanks. Thank you. Next up will be Kevin McGurk.
Hello, can you hear me all right?
Yes, we can.
Okay, can you see me okay? I've moved from the prop area to the car. Let me start by saying, in terms of familiarity with the courtroom, the first question, obviously, as I stated earlier, I've spent a lot of time there. And I think it's important, uniquely important, to have been practicing in a courtroom now, or in the last 2 to 3 years or so, due to the rapid changes we've had in criminal law. It was mentioned earlier, I just got in the car, and I believe Ms. Hammond had mentioned it. It is true that there's been so much sea change, and when you're a defense lawyer and you have a client in court, you need to stay up to speed. We have an implementation problem in our courts right now, where the law in many courts is being applied as it was 3 years ago as opposed to today. So it really is almost experience plus to be in court in the last few years. In terms of maintaining objectivity, I would say, first of all, if you're running for the public's permission to be a Superior Court judge, objectivity should be one of the first things on your mind. It's sort of like knowing how to swim to apply to be a lifeguard. It's a prerequisite. But at the same time, we all have implicit bias and we all have our own unconscious bias. So how I look at it is, I'm always asked, or a lot of times I've been asked, what's your judicial philosophy? And I always say, my philosophy is treat the courtroom like it belongs to someone else, that it's not your living room. Too many judges think it's a fiefdom, and it's not. And if you treat the courtroom like it belongs to the public, that they're allowing you to sit there, that it's a lease without an option to buy, that will inform every decision you make. And that will keep objectivity at the forefront of your mind, because you can be as biased as you want in your living room, but when you're in a cathedral that belongs to the public, the entire public, you aren't allowed to be objective, right? And it's self-evident, of course. So if you think of it that way, it will really allow you to put those implicit biases aside. The second question, I believe, was if there were a law that required me to make a decision that was against my opinion or personal beliefs. Well, the word required says it all. If the law is so explicit that it requires a decision, that's the end of the analysis. I've seen too many judges, if you've been a lawyer for a while, you see the words shall and may a lot in the penal code. And I've seen too many judges try to turn them into synonyms, and they're not synonyms. Shall and may do not mean the same thing. If it's required, if it's so explicit that a decision is required, irrespective of my personal beliefs, it has to be followed. However, in most instances, there is some level of judicial discretion that's available. And of course, I would use that thoughtfully and pragmatically to the best of my ability. But the word required in the question, I think, is self-evident. So if a decision is necessary under the law, I would make it. Right now, as I've stated a couple of times now, we're changing into a certain direction where we have a more balanced judicial system in terms of sentencing. If the public decided to change gears and go the other way, I may not like it personally, but I would have to enforce that law. In terms of explaining things to younger voters, I would say two things. I'd say, one, other than wanting to work in a courtroom, no one expects to be in a courtroom, and yet we're very busy. You may find yourself there and you don't expect to be. So you certainly would want fair, competent, unbiased individuals working on your behalf. So I would try to explain that to them. And second of all, I know the narrative is that young people are untethered from our civic institutions. I don't know if I buy that narrative completely, but I understand why they may be, because the results and frankly the perception aren't where they need to be. We need to do a better job of showing competence and fairness and understanding to people outside of our little personal orbits. So I would explain to them that they're going to own these civic institutions as they go forward. And decisions in courtrooms, whether it's criminal, whether it's unlawful detainer, whether it's family court, our society is intersectional. These have huge repercussions to families, to businesses. It affects them whether they're in court or not. and the resources we use in the criminal justice system or the justice system generally, obviously has a huge impact on funds or resources they may want to apply to other things. So this is something that they need to be engaged in, involved in, and frankly, we need their input to succeed, because we can do better. And maybe one of the reasons we're not doing as well as we could is because we don't have as much input from young people. So I would really encourage them to engage and to frankly help us out, because if you ignore the youth, you do so at your peril. I'll leave it at that.
Thank you, Kevin. That does conclude your time. We are a little, Mr. I think it was Naz Curry didn't show up tonight, so there's only 4 panelists in this room, so we are going to have a little bit extra time. I do have a question for the panelists, and that is, whoever wants to take this, raise your hand or just unmute yourself, and we can go by that. We have approximately 6 to 7 minutes left. And that is, if you were a judge and you became aware that there was some implied bias being exhibited, I don't know why this share screen keeps going to other screens, but kind of along the lines of remaining objectivity in the courtroom, if you became aware that your courtroom staff was exhibiting some implied bias, what would you do within your courtroom in order to identify that and eliminate that within the courtroom in order for you to remain objective and for your court staff to remain objective in the way they treat parties within your courtroom?
Well, if I may.
Yes, was that Kevin?
Well, Albert.
Or no, Albert, sorry.
Yeah. It depends on when you say become aware. If as a presiding officer, I see it personally and therefore, it's more like it actually happened as opposed to someone telling me. It needs to be dealt with immediately. If I've seen it directly, I would immediately deal with it. If preferably not in front of everybody, but I'm imagining in your scenario that there's a proceeding ongoing, and if it happens while the proceeding is ongoing, I think it needs to be dealt with immediately. If it comes to my attention after the conclusion of the proceeding, again, it needs to be dealt with immediately in either case, because the staff needs to know, the employees in that courtroom need to know that everyone needs to be shown due respect. And unless it's dealt with immediately, I think it's going to linger and give the perception that it's somehow acceptable or could be tolerated.
Thank you very much for your response. Let's give Mr. McGurk, did you have a response? I see your hand up.
Yeah, sure. Well, it'll be dealt with immediately either way. There's 2 ways to look at it. If there are attorneys in front of you acting in that way, the canon of judicial ethics makes it clear that not only is a judge not permitted to act in any way that would show bias to another party for a variety of areas, but it gives the judge an affirmative duty to make sure that the attorneys before him or her also don't act in such a way. And if they are, the judge has an affirmative duty under the judicial canon of ethics to act. And that can be anywhere from sanction to contempt proceedings. Obviously, it depends on the nature and how many times it occurs. If it's judicial staff, like the judicial assistant or the deputy, that's probably in a different area than the canon of judicial ethics. And it will be dealt with more in it will obviously be dealt with immediately, and it'll be dealt with swiftly. It just can't be tolerated. And the court perception is just as important as reality. That's the public's courtroom. Everyone needs to feel that they're getting a fair shot, that whatever ruling they're getting is due to a fair and thoughtful application of the law and not some implicit or explicit bias, and it just simply wouldn't be tolerated by anyone in the court.
Thank you, Kevin. Melissa?
Yeah, I mean, I don't want to be repetitive, but just to kind of reiterate some points, I wouldn't tolerate any kind of bias in my courtroom. I would definitely, depending on the situation, talk to the person involved, not in the presence of other people, if I could, because I really think it's very important to treat all courtroom staff with respect. And I see that in my current practice as a DA, as well as when I was a public defender. I really just I'm very respectful of everybody in the courtroom, the judicial assistant, the bailiff, anybody that's there. So I would definitely try to do it not in front of everybody, but I would just make it very clear that such biases would not be tolerated in front of me. And I also think that I would try not to be biased to the extent possible with the cases that I decide. And that's what I currently do as well as a DA. I try to get rid of all my biases when I decide cases. And I know that everybody has some biases inside of them. It's impossible not to have some. And we have to just be aware of them and just try to confront them and just be as unbiased as we possibly can when we're deciding cases.
And on that note, Melissa, that's actually kind of more what I had in mind when I asked the question. So let me direct it more towards that. I think we all do have implied bias, and I don't necessarily think it's always people are cognizant of it. So what would you do in your courtroom to fix it? Like, would you offer training? Would you yourself go to training? Would you ask that, your court staff go to training? Or, are there any methods that any of you would employ in order to help yourselves and the staff identify any implied biases that you may have? Because I think we all do. And to kind of bring a sense of objectivity back to the courtroom through that measure. Melissa, you raised your hand.
Yeah, I just wanted to continue that. So I do go to trainings myself on implied bias. We have some at the DA's office, and there's actually one coming up on Saturday that I plan to attend. But I think it's really important to be cognizant of your own biases, because thinking that we don't have them is crazy. We all have them, we're born with them, and just taking a step back, it's like anything else. You take a step back and you think about the thought process in your head, and you say, okay, I have this implied bias. What do I do about it? So I think that the trainings are extremely important in figuring that out for us. And also I would try to get my court staff, if that was possible, to go to trainings as well. I would have to see what kind of trainings were offered for the support staff, but I'm sure there are some. And I think that it would be extremely important for everybody to understand this issue so that they could rectify it within themselves and just help the court system in general.
Thank you, Melissa. We have just a couple more minutes. Does either Albert or Kevin want to comment on that last part?
Sure.
Go ahead. Go ahead, sir. I'm sorry.
I would just add, I would echo that, but I would also state that I think there should be opportunity for everyone in the courtroom, the staff, the bailiff, to also feel comfortable enough to bring it up to the judge to say, Your Honor, you said something that could have been interpreted this way. Your Honor, you did this. And I think there needs to be that comfort level. And unfortunately, that doesn't always happen. And I think that does come from mandating that both the judge and everyone working in the courtroom participate in these seminars and these training sessions. They should be mandated. I actually thought they already were. And to the extent that they're not, then they need to be.
Thank you, Albert. I just want to give Kevin a quick chance to respond as well.
Thank you. I don't want to belabor the points from the last two speakers. I agree with both counts. We also have training with the PD's office. And I do think that, in a courtroom, anyone that practices court realizes that the judge, the judicial assistant, the bailiff, the court reporter, all court staff, everyone has a role to play in the court to make it go. And so you're in many ways a unit, and that's a conversation that needs to be had before a court day. But look, we understand, we all have to acknowledge, we all have implicit bias. And if you see something, let us know, talk about it. And that's me, the judge, if I'm elected or whatever the case may be, but acknowledging it's the first step. And you need to have those conversations as a collective. So we're all on guard. We all understand that we're having people from all walks of life come in a variety of issues. And if there's ever going to be a problem with, unconscious bias, this is the forum where it's going to rear its head. And it's the last forum that it can. So you really need to have those conversations, more than sporadically, to make sure everyone's on their toes, and to have that culture that people can, freely say, look, you don't realize you did something. And actually, I'm more aware of it than you, and you need to change your behavior. That's something that needs to happen in the courtroom.
Great. Thank you so much for all of your comments. And thank you so much for all of the attendees. I'm going to invite everyone to go back to the main room for some closing comments at this point. Thank you so much.
Thank you.
Thank you.
Welcome back, everyone. I hope everyone was able to get a lot out of tonight's program. And on behalf of the Junior League of Long Beach and the League of Women Voters, we'd like to thank you for attending tonight's forum and learning more about the judicial candidates. We will follow up with all of the attendees via email with the linked videos of tonight's forum when they are posted and made available to the public. Please feel free to share with your friends, family, and professional networks. I'd also like to give a special thanks to all of our judicial candidates tonight for joining, and I hope you found this to be fruitful. I know there's not a lot of these types of forums for judicial candidates, and so we're very excited that you were all able to join us. Please follow us on social media. You can visit jllb.org to learn more about the Junior League of Long Beach and lwv.org to learn more about the League of Women Voters. And again, thank you all so much for attending. We hope you have a wonderful evening.
Hey, welcome. Well, my name is Kirsten Graham, and I am the Advocacy and Outreach co-chair from the Junior League of Long Beach, and I'll be your moderator for this Objectivity, Cultural Competency, and Racial Biases breakout session. So shared with you today is a slide, as you can see, that are just prompting questions that each candidate may choose to address as part of their speaking time. Each candidate will have 4.5 minutes to speak, and the order of each speaker has already been randomly assigned, so I'll let you know when to begin. And then if anybody watching in our breakout room has any questions they would like to ask, time permitting, just submit them to the chat box, and we will address them at the end if there is time. This breakout session will be 30 minutes long and is being recorded and will be posted on the League of Women Voters website for public viewing. At the end of the 30 minutes, all participants will be brought back to the primary room where we'll hear some closing comments. So we will start with Carol Elswick, and your 4.5 minutes begins now.
Good evening, and I'm pleased to be here, and thank you for the invitation. I feel like judges, like everyone else, are human beings, and therefore, in my opinion, like everyone else, judges do exhibit implicit bias. Having 30 years of judicial experience, I apply law to the facts that are presented to me and rule accordingly. And to ensure that my decisions are not unduly influenced by possible implicit bias, I'm mindful to ask myself, has a person's race, person's ethnicities, religious beliefs, or lack thereof, their sexual identification, their social economic status, their disability, their citizenship status, their immigration status, their mental health status, has that influenced my rulings or my decisions? I think that's very important. It takes a number of years on the bench to recognize that we all have implicit bias. And I constantly ask myself, again, those questions, has that influenced my ruling or my decisions? And I think that's very important. At the same time, I want to follow that up with the following. When I perceive, sometimes I do perceive, my attorneys in the courtroom, I should say the attorneys that are assigned to my courtroom, sometimes they might be influenced, unduly influenced by implicit bias. And I ask them to distinguish the facts in case A from case B to ascertain the reasons for perhaps an increased prison sentence or increased jail time, increased community labor, community service. I'm going to ask them to distinguish the facts in case A from case B to make sure that that implicit bias does not affect the persons before the court. And I think that's very, very important. Sometimes they say, well, Your Honor, this case is a little different because of A, B, or C. And I say, let's take a look at the criminal history. Are their criminal histories the same? There's no criminal history. And I just have to dig deeper to find out, why are you treating A different from B? And sometimes they can't give me an answer. And if I can't get an answer from them, I invite them up to the bench so I can we'll go off the record and I say, hey, look, I'm not seeing a difference here. And sometimes they'll be honest with me and say, well, so-and-so went to a good school. So-and-so has a good job. And I'd say to them, well, wait a minute here. Just because someone went to a good school or has a good job doesn't mean they get a lighter sentence. Okay, we have to be fair, we have to be equal. Someone who doesn't have the advantages of going to a good school or doesn't have the advantage of having a good job shouldn't get a lighter sentence. And that's the implicit bias sometimes. Sometimes it isn't always race or ethnicity. Sometimes it's somebody doesn't have particular advantages. And so I'm always mindful of that, whether it's myself or the lawyers or the parties involved, and that's very, very important. I do look forward to your questions. I'm happy to answer some of those questions. I'll even go to another part of some of the sub questions that you have. With respect to, I think one of the questions was, how do we increase diversity on the bench or those sorts of things? Just last week, I was up at the California Judges Association mid-year conference. One of the breakout sessions included diversity and inclusivity and how do judges build bridges. And we talked about how do we build bridges by way of mentoring and internships. And that was an hour and 15 minutes in that particular breakout session that I attended. And just today I spoke with one of my interns from years ago, 2004. We've been in a friendship ever since then. One of those interns was a Cal Poly student. She was interested in becoming a lawyer, a criminal lawyer. And so she was with me for about 3 months. After completing that, she graduated from Cal Poly. She ended up being a tutor for my children from grade school in the area of math through college, or entering college. And as I said, we've remained friends. She didn't follow her aspirations of going to law school, but then she became an entrepreneur. She is a person of color. She currently in her business has a tutor.
Carol, that's your time.
I'm sorry.
No
Thank
worries.
you. Look
Thank
forward
you.
to your questions. Thank you.
Thank you. Yes, and then we have Carolyn Park, and your time begins now.
Thank you. So my my view is that judges absolutely exhibit implicit bias. As the previous speaker said, we all as human beings have implicit biases to some degree, but it's incumbent upon us as legal workers, attorneys, and judicial candidates to do the self-examination and do the internal work of de-biasing ourselves, it's so that we can be the best attorneys and judges that we can be. So my view of bias and race and objectivity is very much informed by critical race theory, which says that race is a social construct and that our institutions, including the criminal justice system, education system, our workplaces, are laced with racism embedded in our laws, our regulations, our rules, and that these laws and regulations and rules and procedures lead to different outcomes by race and disproportionately affect especially African American and Latino populations. And the problem with implicit bias is that you don't know what you don't know. And even when you do know, it's extremely difficult to be completely unbiased or to extricate oneself from the various isms in our institutions. And it's also difficult to not uphold in some way the unfair institutions that we have. That said, we have to do the best that we can. And so I'm interested in how we can tackle this monumental problem. And one of those ways is, as I've alluded to, is to do our individual work on ourselves. We have to, in order to be aware of our implicit biases, we can read about critical race theory. We can learn about history, the history of injustice in this country. I was a history major and an Africa and diaspora studies major. And I've also intentionally made myself a part of diverse communities, and being part of diverse communities is also a way of debiasing ourselves. I've also chosen a career representing people from all walks of life. So as a staff attorney and as an attorney in private practice working in civil rights and many other matters, I've represented people from indigent folks to custodians to tax auditors and nurses, and that to deal directly with people who are system impacted is also how we can break down implicit biases so that we can view every party that comes through the court system as a full human being with hopes and dreams and families and lives that are impacted in various ways by our legal systems.
Time. Thank you.
Thank you.
Mhm. And next we have Elizabeth Lashley Hayes, and your time begins now.
Yes, thanks so much, Ms. Graham. This is one of the topics that's very near and dear to me. So I'm really honored to be able to be here with everyone and discuss all of these really important issues. I'll take the first question, which is, do I believe that judges exhibit implicit bias? That would be a definite yes, because as several of the other speakers have mentioned, we all have implicit bias. It's not solely judges, but it's everyone. I think what is extremely important is that if judges don't recognize their implicit bias and try to counteract that, the results of that can be extremely dangerous. So if all human beings have implicit bias, but you work at a grocery store, that may not have a horrible, dangerous sort of impact. But for a judge, unaddressed implicit bias could result in extremely inequitable outcomes in people's lives and liberty. So I have very particular experience with this because currently right now, my job is to litigate the Racial Justice Act. This was a bill passed as Assembly Bill 2542. It was codified into Penal Code Section 745. It's a new law that deals explicitly with implicit bias in our legal system. So I have brought claims of implicit bias, and I've brought them in multiple courtrooms throughout the county. One of the common things that I see is that there are judges, not all, but there are judges that don't understand what implicit bias means. And I see that in the way that they're ruling on my Racial Justice Act claims. So they bring up explicit bias and they'll claim like, well, you didn't show how this particular client, there was racism against this client. And I try to explain, well, no, this is implicit structural racism. And the judges I see after a long time of litigating it, that they don't really understand what implicit bias means. And to me, again, that's very dangerous. If you don't really even understand what it means, then how could you work to recognize your own bias? I would say that I am a part of a statewide group that works on the Racial Justice Act. And one of the things we've been discussing is more training for judges throughout the state of California on implicit bias. In terms of what I would do to ensure that my decisions, if I were on the court, were not unduly influenced, I've thought a lot about this. And there's a concept in the prosecutorial world called blind filings, where some more progressive prosecutors have the name, the identifying characteristics about the people who are arrested blacked out, so that they are not influenced by that when they make decisions about how to file a case, what they're going to file. And I thought that's such an interesting concept to try to counteract implicit bias. And I thought, is there any way that I could do that on the bench? And I thought of one way, of course, I can't do that out in court, but I thought maybe if I'm reading a motion and I worked with my judicial assistant to keep the name and any identifying information, could I read motions in a way that it was blind to myself, so that I wasn't influenced in any form or fashion by the characteristics of the people and the defendant and the victims in the motions in front of me? That's one creative way I thought about trying to safeguard against any implicit bias I may have. And in terms of what I have done to increase diversity, equity, and inclusion in my legal community or in the judicial system, this is something I've been working at extensively for years and years. And I serve on my office's racial justice committee, or I served on that committee before I decided to run. Part of that committee, we examined what we could do to increase diversity, equity, and inclusion in our office. I came up with a particularized training that we did for 12 months where we tried. Thank you so much.
And next up is Bryan Dibble, and your time begins now.
Thank you. That's a very pertinent topic, and just as everyone else has said, I do believe that everyone has implicit biases. And, luckily now, including in the DA's office, we're receiving training on it. There are certain laws that are evolving. And so, we're all, it's incumbent on all of us as, parties to criminal cases and ultimately on the bench to be aware that this exists. I've seen the impacts of implicit bias and bias as a DA, just, some of the assumptions that people make about folks, whether they're the accused or victims or witnesses who are brought to court. A lot of times I've even seen that people that I'm interacting with who make assumptions about, me being a prosecutor. And, that if they don't show up to court in response to a subpoena, that I'm going to, automatically, ask to put them in jail, or that I don't understand, what a victim is dealing with because their experiences in the community and having suffered from a crime are different from my own. So, I have in my career really worked hard to, put myself in the shoes of different folks who have different life experience than me. I have never been the victim of violent crime, but I have convinced and talked to and counseled many victims of violent crime and witnesses to crime who are afraid to come to court to go along with the process for reasons where I'm kind of meeting them halfway. I'm not just asking them to come to court, because that's what I'm interested in doing for the case. I'm doing it in a way where I want them to feel comfortable. So I think that, I've had to work around a lot of those issues that have come up. And as a judge, I think it would be incumbent upon me to be aware of my own implicit bias. Again, from where I, grew up and went to college, there's going to be many, many people that come into court who have different life experiences. And so we have to constantly be vigilant to know that, there are things that we're not even thinking about that, might factor into a decision. It's not cool. We need to really take the time to address that potential and make the best, most objective decision possible, knowing that people come from different walks of life. I feel that I've been well trained and have the experience and human skills to be able to do that, just with my experience interacting with so many different members of the public in my job. In terms of what I've done to increase equity and inclusion in our legal community, just taking the time with the witnesses and victims of crime that I interact with on a daily basis to explain to them what's going on in the court and to put it in human terms, no matter who a person is or what their education level is or background, that, you know, everyone deserves to understand why they're in court. If they're a victim of crime or a witness to something, they're there unwittingly. And I've always tried to just make people feel welcome in the courtroom, welcome and participation, active participation in the process and be aware of what's going on. And I just feel like I'm an inclusive person that way, and that I have a good knack for explaining things in human terms. And, you know, as a volunteer with Project Lead, I've also gone out in the community to try to teach fifth graders about, you know, the criminal justice system and different aspects of peer pressure and things like that. And so, you know, I always just try to increase people's knowledge about what's happening in court. So I'm cognizant of the fact that implicit bias exists. I think that's the key, is just everyone needs to know so that they can, you know, fine tune the way they make decisions in the way that's appropriate and expected in a court of law.
Thank you, and that is time. And now we'll have Renee, Yolanda, and Chang, and your time starts now.
Hi, so as everyone said, we all have implicit biases and we are formed by the various cultures and the life experiences that we have. And I think that what we need to do is not deny it, but recognize it and not act on it and try to take it out. But I want to talk about how it affects not only the accused, people who are accused of crimes, but it affects victims of crimes. We all have implicit biases against victims of crimes for certain things. For example, I am the supervisor of a unit that prosecutes sexual assault and domestic violence cases. And I have seen over the years, especially women from minority groups, Latino groups, members of the API community, they don't often come and report these crimes, not the first time, not the second time, not the third time it happens. And when they eventually do come to report these crimes, one of the things that we have to overcome in court is this bias against these victims because, well, you know, if this person had beat them all these times, why did they keep going back? If this person, if their spouse had raped them all these times, why did they keep going back? Why did they never say anything? So these are something that we are constantly dealing with in my unit, and we are constantly trying to help these victims be heard in court, and we have to overcome these, not just with the courts or the judges, but with the juries as well. So I deal with this every day. As a judge, of course, I would continue to take training, as I do in the DA's office, regarding implicit bias to make sure that it doesn't impact me in any of my decisions. And I would continue to do so if I'm elected to the bench. As far as increasing diversity, equity, inclusion in our legal community, I've also participated in Project Lead, which involves members from our office going into underrepresented areas and schools and teaching fifth graders about the justice system and the judicial system and about decision making. I am also a supervisor and I mentor young attorneys of different races, different genders, and I try to help them advance their career within the judicial system. I've worked with law clerks and mentored law clerks as well. And again, coming around to a victim perspective, victim-based approach, I also participate in these community groups, specifically the sexual assault response team in the South Bay where I work, where we have community advocacy groups for these underrepresented groups and minorities. Oops, have I been cut off? Is that my time? Well,
no, I apologize. You have a minute left.
That's okay. I'll finish it with that. So I have done a lot within the community and within the legal community to help promote diversity, as well as being a diverse candidate myself, being a female Asian candidate, but I'm not running simply on that. I am running also as the most qualified in my seat.
Thank you so much to all of our candidates. And now we have some time for questions. And just a reminder to anybody in our breakout room, if you have any questions, you can add them to the chat. And then we'll go ahead and do a reverse roundtable, about a minute each for a quick question here, just as we wrap up our time. Does anybody have any questions to add to the chat or live as well? And if not, I will allow each candidate to provide a closing statement, 1 minute on this topic or as a whole. And we'll start in reverse order. And so Renee, you can go first.
Thank you. As I said, I've been working in the criminal court system for 27 years, and my other candidates in my seat have also been working in the court system for a long time. But I have the endorsements of the Metropolitan News Enterprise, which is the legal newspaper covering the courts in Los Angeles County. I have the highest rated LACBA rating, which was well qualified, against 2 of my competitors who are rated not qualified and 2 who are rated qualified. I have the endorsement of over 60 Superior Court judges, many of whom are former public defenders with whom I actually tried cases against. And these people represent me, and these entities represent me because they know I am fair, and I will be a fair and impartial judge. And I have the support of law enforcement and a victim advocacy group, Crime Survivors PAC. And I believe that based on my experience, based on my background, I will be the best candidate. And I thank you for your time, and I ask you for your support.
Thank you. And now we have Bryan.
All right, thank you very much. On this topic, I can't stress enough that in my role as a prosecutor, I've really, tried to improve my own skills in terms of being able to put myself in the shoes of people whose lived experience is different from mine, people who look different from me, people who grew up in different area, have a different education, whatever the case might be. I'm somebody who recognizes that both as a prosecutor and ultimately as a judge, I'm going to have to do that because that's how a fair assessment of the cases that will come into court is going to take place. The law tries to be objective with the application of the law and its fairness, but in order to understand people and why they might be in the system, or why to understand someone's fear of testifying or something like that, a judge does have to be in a position to understand different life experience. And so, it'll be incumbent upon me to be able to understand that as a judge.
And next we have Elizabeth.
Thanks so much. I can't stress how important it is to have judges on the bench that have a deep understanding and also a commitment to overcoming their own implicit bias before they occupy such an important position. My commitment to overcoming racism and doing anti-racism work and doing implicit bias training and work is deep and long-standing. It began 25 years ago when I was in college and I traveled to South and studied colonialism and oppression. And it has traveled from that point until today. In the fall, I visited the equal justice initiatives from enslavement to incarceration museum. I visited the lynching memorial. That was my second trip there because I think that if you are going to work in the legal system and you are especially going to be on the bench making those important decisions, it is critical that you understand the history of the legal system and the racism that it is rooted in and work hard to overcome that. Just on my off time. Oh, thank you so much.
Thank you, Elizabeth. Now we have Carolyn, and your time begins now.
In light of recent events, we know that perspective and values are just as, if not more important than qualifications in judges and judicial candidates. And my perspective and my values are informed by my lived experience as a Korean American woman in America. My perspective is also informed by being a community lawyer who has represented people from all walks of life, from all of all races, abilities, income, genders, sexual orientation. And that is the critical difference between me and the other candidates in my race.
Thank you, Carolyn. And last but not least, we have Carol for your final statement.
Thank you. As I've indicated, I've been on the bench for 30 years, and LA County is such a diverse community. By diverse, it's diverse in terms of race, ethnicity, religion, agnostic, diverse in terms of sexual orientation, diverse in terms of wealth, not wealth, citizenship, immigrant, and the like. And when we talk about implicit bias, those are biases as well, or biases as well. And I've served all of those people, and I continue to serve those people, and I'm constantly mindful both of my own implicit biases, and I take all that in consideration. I do my best to take all of that in consideration each and every time, because when I see the scales of justice, they need to be balanced, absolutely need to be balanced. And so I try to be mindful of that in each and every decision I make. And I ask myself, am I treating this person differently because of this, that, or the other? And I do the best of my ability to try and be fair and impartial to everyone who appears before this court, because I want that person to feel that when he or she or they walk out of the courtroom, that they were treated fairly. So the next case that is identical to that case, factually speaking or criminal history wise, that they were treated fairly.
Thank you, and that is time. A huge thank you to all our candidates for your time. We will go back into the main room shortly.
Welcome back, everyone. I hope everyone was able to get a lot out of tonight's program. And on behalf of the Junior League of Long Beach and the League of Women Voters, we'd like to thank you for attending tonight's forum and learning more about the judicial candidates. We will follow up with all of the attendees via email with the linked videos of tonight's forum when they are posted and made available to the public. Please feel free to share with your friends, family, and professional networks. I'd also like to give a special thanks to all of our judicial candidates tonight for joining, and I hope you found this to be fruitful. I know there's not a lot of these types of forums for judicial candidates, and so we're very excited that you were all able to join us. Please follow us on social media. You can visit jllb.org to learn more about the Junior League of Long Beach and lwv.org to learn more about the League of Women Voters. And again, thank you all so much for attending. We hope you have a wonderful evening.
Hello, my name is Summer Smith. I'm going to be the moderator for this particular session, which is the juvenile justice session. Share with you today, actually, I'm going to be sharing the prompting questions for this particular session. Each candidate may choose to address, all or part of the questions that are going to be shown. And you will each have 4.5 minutes to speak on this particular topic. And you can address all of the questions or one of the questions. It's your choice. The order of each speaker has been randomly assigned. If anyone watching has any questions they would like to ask, time permitting, please submit them to me in the chat box. This breakout session will be 30 minutes long, is being recorded, and will be posted on the League of Women Voters website for public viewing. At the end of 30 minutes, all participants will be brought back to the primary room while we will hear some closing comments. The prompted questions addressed in the session are explain to us your experience with the juvenile justice system and how it functions. Do you feel it is a fair system, and what do you feel could be improved? What can judges do to ensure youth are given fair consideration in this system? So I'll leave those questions up. And then the first person to start us off will be Melissa Lyons. Are you here, Melissa?
I'm here. All right. Setting my timer so I can see.
Perfect.
Awesome.
All right. Melissa, go ahead and begin.
Great. Good evening, everyone. And so I'll go in order of the questions as shown. My experience with the juvenile justice system began with the DA's office. I served a year in juvenile at Eastlake Juvenile because our office does require us to do a rotation through a juvenile courthouse. And how it functions currently, however, as of about 6 months ago, I'm now the supervising deputy district attorney for Compton Juvenile Division, which gives sort of a different perspective of the juvenile system as a supervising DA than I had as a courtroom DA. In terms of how it functions, I mean, it's multiple departments sort of working with each other to come up with the best solutions for a minor. When a minor is arrested or cited, probation reviews, the probation department reviews that arrest report. They then make a detention report if they're detained, or they do a PPR report, which basically looks at the minor's background to some extent, looks at the facts of the case and makes recommendations based on that for the court to consider. The court can go with that recommendation, or the court can choose not to go with that recommendation. Unlike adult court, there is no jury at any point. There's no jury trial at any point. We do have what are called adjudications, but those adjudications, which are probably the closest thing to a trial, are essentially a court trial where the judge makes the decision on what happens with the minor. So obviously the judge's role is that of the trier of fact in making decisions on whether or not to sustain a petition, which is in adult court would be the equivalent of a conviction. So judges are very important in juvenile court because they have a lot more decision-making sort of power in juvenile court as compared to adult court. Do I feel it's a fair system? I think any system that involves human beings is gonna be unfair to some extent because people bring with them their various biases, and their biases affect how they make decisions, how they present information, and so those things on all levels, not just from the perspective of the judicial officer, but even from the perspective of witnesses, victims, the minor themselves. All those things affect, I think, the fairness of the system. I think the way that we improve that is continued education for decision makers, especially in the area of implicit bias, ensuring that our decision makers understand where they have blind spots or make assumptions about the people that come into court, whether they be victims or defendants, and about the source of their behavior. But also, I think education with respect to understanding trauma and how it affects, thank you, how it affects a person's behavior, again, both for a victim as well as a defendant. When you can understand how sort of behavioral issues, mental health issues, substance abuse issues, family issues, and other forms of trauma sort of intersect in a person's life, and how it sort of colors their behavior, their ability to communicate. When you understand those things, you're able to make better decisions for everyone involved, and it'll inform how you take testimony from a witness as well, in terms of understanding a witness's behavior or a victim's behavior in a particular situation. So I think it kind of dovetails into that last question of what a judge can do. And I think the greatest thing a judge can ever do is educate themselves beyond the law, but also about people.
Okay, so next up we have Thomas D. Allison. Thomas, are you in the room?
I am, thank you. If you don't mind, I'll get my clock going.
Yep.
All right, our kids, I believe our kids no longer have the right to be kids. I believe society should care about juvenile justice before something bad happens. I believe in a truly free and equal society. All youth have equal opportunity to access resources and success. One of my early experiences as an attorney was representing a 16-year-old girl in an attempted murder trial. She was charged as an adult. I saw the full weight of the system come full steam ahead at this teenager, and I was her only representation of justice in this process. I have represented youth in several cases, including possession of marijuana, robbery, and theft cases. In all of my cases, I reached agreements with the district attorney where my client paid restitution, did community service, had education stipulations, and other things, and their records were sealed. Most of the youth that I've represented have gone on to college. A few of them are on the path to becoming lawyers themselves. And this is because the primary goal of the juvenile justice system is rehabilitation. The parties are supposed to work to come up with the best disposition for the youth that would put them on a path to success rather than a life of crime. But we all know that the school to prison pipeline still rages forward. This is where I think the community comes into play. I do not believe our efforts for rehabilitation go far enough. I strongly believe in a teen court where minor cases are handled by the youth's peers. I believe in restorative justice, and I believe it should be an inherent part of every single case. This means taking a holistic approach to rehabilitation. There would be no adjudication in my version of juvenile justice. The youth would be assessed, provided wraparound services, and continue to make progress reports until it is clear they are fully rehabilitated. This might mean requiring them to get mentors. This might mean providing them with healthcare, transportation, and other personal needs that they have that would deter them from a life of crime. There's a concept called bounded rationality. And basically this concept means that we only act as good as we know our options are available to us. And I believe that our juveniles just don't have a broad enough perspective of what their opportunities are. I mean, we have kids who never even leave their neighborhoods. They have such a small perception of their world and their role in it. And I think that we can do far more to expand the bounds of their rationality so that they understand more that they have something to lose and that they are just as worthy of accomplishing great things, no matter their background, as their peers. And I think this first step in realization means that we have less chances of having bad things happen because our juveniles are more focused on accomplishing success. In my system, I think there should be more restorative processes where the juveniles actually interact with the victims. This way they have a better understanding of what they've caused, their role in society, and they're able to humanize people in a level that would make them second guess or second think ever creating another victim. Once they are rehabilitated, then the whole thing would just go away. There would be no such thing as sealing records. There'd only be documentation of the fact that they have successfully completed rehabilitative services. And this could be something that can be used on a job or college application. I believe judges should be role models. I got to speak at Locke High School in Inglewood, and there are many challenged youth in this high school. They were so impressed and well-behaved during my session. And it had a lot to do with the fact that I shared life experiences with them and had the respect for them to come and talk to them and spend time with them. As a judge, I believe that the relationship with the youth should pre-exist any court case, and that judges should play roles as mentors to youth prior to adjudicating them guilty or not guilty. These are just a few of the examples and some of the experiences that I have with our juvenile justice system.
Thank you so much, Thomas. All right, we have Matthew Vadenoy is next.
Yes, hi, thank you. Hi, Matthew Vadenoy. I am running for seat 70, and my experience in the juvenile justice system was for about 14 months while I was a deputy district attorney. I worked every single day in a courtroom, running that courtroom and the juveniles that went through that courtroom and adjudicated them. I think that having that experience was an invaluable experience that actually was one of the most beneficial things I ever did as a deputy district attorney, because it really opened my eyes to some of the failures of our system. Now, I think Melissa Lyons gave you a great explanation of what the juvenile justice system is and how it functions, so I'm not going to get into that. What I will tell you, and the one thing that she said that I completely agree with and would want to emphasize, is that it is the bench officer that has all the power in these courtrooms. And that's why the juvenile courts are so different depending on which courtroom you are in. But one thing I did learn that is so important that we need to keep in mind is that the accountability matters. You can't just say to somebody, I'm going to take care of you and give you opportunities, and I'm going to make it so that you're fixed. And I'm not saying people can't be, because the whole point of the juvenile justice system is rehabilitation. And there are people that are success stories from juvenile that grow up to be great contributing members of our society. But there are people that go through that system, and when you work in that system every day, they know the difference between right and wrong, and they do wrong. And they need to know that they need to be held accountable. I'm not saying we need to punish them or put them away or throw them away like garbage. What I'm saying is, if you're a parent and you're running a juvenile justice system in your home like I do, if somebody doesn't listen or somebody takes a cookie that they're not supposed to, they're held accountable. If someone kills somebody that's 16 years old, they need to be held accountable. If somebody runs a red light going 150 miles an hour because their father bought them a Lamborghini and they just don't care, they need to be held accountable. If somebody is 17 years old and they go out with all of their gang member buddies and they kill people and rob them and carjack them, they need to be held accountable. That's the point of the juvenile justice system, not just rehabilitation, but accountability. We cannot teach our youth to respect the law and respect our culture if they are never taught that what they do is unacceptable and wrong. Now, I am 100% behind rehabilitation, offering services, all the things that I think would be great to help the Los Angeles County system. Our young people are clearly being left behind, and oftentimes in some of the areas that don't have the same funding are left to their own devices. And when that happens, they don't have guidance and leadership, and they go and they do things they shouldn't be doing. And sometimes there are adults that are leading them astray. But what we don't do is say to those kids, it's okay, don't worry about it, never mind. We have to teach them that it's wrong. And unfortunately in the county and in the state of California, we don't fund the services that we need to fund to stop these things from happening in the first place. Things like after-school programs, hot meals, supporting families that need housing, supporting families that need money because they don't have work. There are all these things I think flow into the juvenile justice system when a young person comes in that has no family structure, educational structure, and they see things in their community going on that are the things that lead them astray. And we don't have the structure and the infrastructure to provide them safety, opportunity, and potential. Now, the juvenile justice system is not where that happens, but it can be part of the system that helps that happen. And what's important is to know that judges have the ability to take into account in the juvenile justice system way more than they do in the adult court system. Their schooling, their family, their background, everything is much more incorporated into the analysis. And that is not to be used as an excuse, but to be used as a point of evaluation. I am a firm believer that, I guess like Whitney Houston said, children are our future. And we need to make sure that the ones that need the support get it, that we don't throw them away like garbage. And I think the juvenile justice system has some of the things in place, but it can do better. And we can do better as a society. But what we can't do is tell them it's okay to commit crimes and it's okay to follow that path. But we need to give them the support and the help that they need. And that, if I was a judge in that system, what I would try to achieve. Thank you.
Thank you, Matthew. All right, next we have Keith Quijano. Are you here, Keith?
I am. Thank you, Summer. Good evening, everyone. I'm Keith Quijano. I'm running for seat 118. My experience with the juvenile justice system is a little bit different from my colleagues in that I served a year at what used to be the Kenyan juvenile justice system. I do like the approach that was followed in that courthouse, which unfortunately is no longer open. The approach that that courthouse took was to take all of the minors who had been charged with crimes within the Watts area, and if they were to be arrested on other charges, regardless of where those charges happened geographically, they would always be brought back to the Kenyan juvenile justice system, I should say the courthouse, with the idea being that the bench officers, the probation officers, the district attorneys, and the defense attorneys would know who the minor was and would get to know the particular needs of the minor. I think that that is a crucial and important characteristic of the juvenile justice system, in that the people that it encompasses are still being shaped. They're still growing. Their minds are still developing. And that development happens at different rates for every individual person. I think that judges who actually preside in the juvenile justice system have to have a wide breadth of experience to understand that. These judges need to have experienced different areas of the county, need to understand that different communities function differently, and that children and minors in different communities act differently. They respond differently. Given that, I think the juvenile justice system is properly geared first and foremost towards rehabilitation. I think that judges who preside in the system also need to have a firm understanding of when rehabilitation might not be a possibility, and the more appropriate function or remedy may transition into punishment. There is some point at which some minors do have the understanding of the culpability and the intent behind the crimes with which they're charged. And I think that, again, it is incumbent upon a judge to have the appropriate breadth of experience to make factual determinations and to actually care enough to listen to all of the evidence that's provided in making the proper decision for each individual minor. I have very specific experience with respect to a minor who committed a murder when he was 17. I'll just tell you that it was very heart-wrenching to speak with him, because he ultimately became a witness for the people in a separate murder case. And what I saw in him was a remarkably sharp young man who was essentially no different than I, but for a stroke of luck in terms of where we grew up. I learned from him that rehabilitation as possible. As I watched him mature, I saw him arrange his own leniency agreement when his attorney dropped the ball. I saw him educate himself with respect to Senate Bill 260 and youth offender parole hearing eligibility. And I saw that change can be effectuated. I think that kind of experience is important in terms of what happens in the juvenile justice system, and that judges have to be cognizant of those differences. I look forward to your questions. I do think I have unique experience, and thank you so much for having me.
Thank you, Keith. Okay, next we have Leslie Gutierrez.
Hi, everyone. Similarly to Keith and Melissa, my experience with the juvenile system comes from being a deputy district attorney. I was in the juvenile system in Pomona for a year. The interesting part of being in Pomona is that we have a lot of the camps where the juveniles would be sent to in close proximity. So we would also get, in addition to crimes that were committed, in the community, we also had crimes that were committed within the camps themselves. I think the juvenile assignment is one of the most powerful assignment that you could have in the DA's office. We get the chance and the opportunity to really try to shape the youth and try to get them completely out of the system. The goal of the system as the juvenile system is rehabilitation. And we work in conjunctions with social workers, with probation officers. It's a group effort. We have county council that also comes to the hearing. We work really as a team with the public defender to try to figure out what we can do to help these people, to help these kids, so that they actually get on the right path and do not enter the adult system. Most of the time it is effective. We have good programs for them. Sometimes it's not. And I've had the misfortune of having defendants in the adult sides that I had as minors in the juvenile system. And it's always, really sad to see that the system has failed. But we also need to take in consideration whether or not they wanted to be helped and whether or not they were helped. I'm so sorry. My throat is burning. We have to, really try to help people, but they also need to want to be helped. And sometimes I had a kid who was, 12 years old, and he was part of a family who were gangsters, and he was himself, a gangster, and, it was hard. But, we had to understand that this was his family path. And as much as we were trying to help him, he kept coming back. And the last time that I had him, he had assaulted someone in the bus from camp and tried to strangle him with his handcuffs. So, he had to be held accountable as well. The juvenile system, as Melissa has said, is like any other system. When you have human behaviors and human beings, we're going to have mistakes. So it's as fair as it can be. But there are issues, and there are issues also with the laws, where a 16-year-old in the juvenile system, if he's charged with a strike offense, will carry that strike offense in the adult system, but they don't get the benefit of actually having a jury trial. And that's something that I believe should be done. We should have jurors in the juvenile system if the juvenile wants it. The issue is that those hearings are confidential, so it would be a tough way or a tough job to try to have jurors come in, because they would have to be bound by confidentiality, and we all know how that works when we have human beings. But when you're 16 and over, and you get a strike in juvie, it's going to be a strike as an adult as well. So if there is an offense that's committed in the adult court, unlike the other offenses that are sealed, this one will not be. We will be able to see that you have it, and it will be used in the adult case to make your sentence longer. So, there are issues with any system. That's one of them that I see with the juvenile system. Obviously, judges can do a lot to be fair. They can listen to the needs of the children and the minors that we have in court. They can try to find the right programs, and they can instill change within the kids as well, within the system.
Great, thank you, Leslie. So we do have a little bit of time left in this particular breakout session. I wanted to give each speaker or presenter a 1-minute opportunity for any closing or responsive remarks. It could be to anything anybody else said, or it could be, based on whatever topic you feel like you would like to finish out. We'll start again. Have Melissa Lyons come back on. Melissa, are you here?
Yes, I'm here. Thank you.
Perfect.
In terms of closing commentary, I think the best that I can say in the context of judicial officers and choosing judicial officers and understanding their role, I think it's important to have judicial officers, whether in the juvenile system or otherwise, that are committed to making good decisions and making good decisions by understanding the people that are in front of them. I think whether we are in, like the juvenile system is, one that is focused on rehabilitation, or one that is more focused, as the adult system is a little bit more focused on penalty and punishment, I think it's incumbent on a judge to understand the people that are before them, and that comes through interaction with people from all over, from different walks of life, and educating yourself again outside of the law. I think that is critical for a judge to do.
Perfect, thank you. Okay, next we have Thomas D Allison.
I'm just going to speak honestly. When it comes to youth, I don't like the fact that we're so quick to go to the youth that need to be held accountable, or don't want services, or not able to be rehabilitated. There are so many kids and youth who can be rehabilitated, who needs the right services, but we don't talk about them. We go straight to holding our youth accountable. And I think that's a disservice for our community and our youth. As judges, I think we need to be poised to do what is best for our community. And that means being open to treating our youth for exactly who and what they are, our youth. They deserve a chance, accountability, of course, but they deserve a chance. And that's why I think our conversation should be not just about keeping the same things the same things. Thomas Allison for judge.
Thank you, Thomas. Appreciate it. All right, next we have Matthew Vadenoy.
Thank you. I may be interrupted by my dog, who would like to make my closing statement for me. But the truth of the matter is, it's somewhere in between accountability and rehabilitation. There is not one solution to every single case and every single young person that goes through that system. Some of them will benefit from rehabilitation. I wish it was every single one of them, but some will not. I wish there were enough services to give every single one of them the services that they deserve in our society, but we don't have those resources allocated. And so we have to know, as a system, Barkley, we have to, as a system, as a bench officer, understand the difference. And that's why, when I said earlier, the bench officer has all the power and is the most important person in that courtroom, I mean it, because they're the ones that are ultimately going to decide the future of these young people that come through these courts, whether it's going to be one or the other and what's the right fit. And hopefully, I hope for all of us that the juvenile justice system is not even necessary, but for now it is.
Thank you, Matthew. Okay, next we have Keith Quijano.
Thank you, Summer. I think the most important thing for a judge in the juvenile justice system is to listen. That's important for any judge, but very, very important for a juvenile justice judge, because of the change that can be effectuated through the juvenile justice system, and because of the long-lasting effects that decisions that a judge makes can have. those decisions have to be based on solid experience with a wide range of people from a wide range of communities, so that justice within the juvenile system is applied fairly across the entire county and regardless of socioeconomic status or geography. I think that what's important for your candidate is to have that life experience with which to make the appropriate decisions. Thank you so much.
Thank you, Keith. Okay, next we have, to close us out, Lashley Gutierrez.
I agree with what's been said by my colleagues. Obviously, you need people who have the right experience. As deputy district attorneys, we've been in the juvenile system for every day for an entire year. And I don't agree when I hear that the goal is accountability all the time. We've been trying for years to provide services to youth and to try to rehabilitate them. Now, when there are people who keep coming back and committing violent offenses with weapons or murders or attempted murders or violent acts upon others, then there is a need for accountability and there is a need for the criminal justice system to be there and hold this individual accountable for their actions. So that's when judges have a role. They get to decide what placement to send people to. Do we give them another chance? Do we put them on probation? Did we add an ankle monitor? Do we send them to camp? And if we do send them to camp, for how long? And do we look at whether it's working or not? So judges have a lot of tools at their hand. Oh, thank you, sorry.
All right, that closes up our breakout room session. I'm going to stop the recording and we will all go back to the main room to hear final closing comments. Thank you so much for participating this evening, and we will see you in the main session.
Welcome back, everyone. I hope everyone was able to get a lot out of tonight's program. And on behalf of the Junior League of Long Beach and the League of Women Voters, we'd like to thank you for attending tonight's forum and learning more about the judicial candidates. We will follow up with all of the attendees via email with the linked videos of tonight's forum when they are posted and made available to the public. Please feel free to share with your friends, family, and professional networks. I'd also like to give a special thanks to all of our judicial candidates tonight for joining. And I hope you found this to be fruitful. I know there's not a lot of these types of forums for judicial candidates. And so we're very excited that you were all able to join us. Please follow us on social media. You can visit jllb.org to learn more about the Junior League of Long Beach and lwv.org to learn more about the League of Women Voters. And again, thank you all so much for attending. We hope you have a wonderful evening.
So I think we'll go ahead and get started. My name is Jane Bemis. For those of you who might have missed me originally, I'm the president of the League of Women Voters of Long Beach area. I'll be your moderator for this session titled Pandemic and Civil Unrest Impacts. I'm going to share with you today the prompting questions that each candidate may choose to answer as part of your speaking time, either all or part. You each will have 4.5 minutes. I have a timer here and I'll let you know when your time is up. The order of each speaker has been randomly assigned, and I will invite you as we go through the list. If anyone watching has any questions that they would like to ask, time permitting, please submit them to the chat box. At the end of the 30 minutes, all participants will be brought back to the primary room where we will hear some closing comments. Okay, so we are going, let me see if I can get my screen. Here we go. And there we go. So first up, we have Clint Mckay.
Thank you. Do you want me to answer all three of them, or are we doing them in order?
The intent of the questions is to just sort of guide you through your response. But whatever thoughts you may have with regard to the pandemic and civil unrest impacts.
All right. I will tell you that the first question is, what changes have been made in the Superior Court system due to the impacts of COVID-19? What would be lasting, and what do you feel will subside with time? I will tell you that in the cases we hear, they've all gone to virtual. We have almost everything by video or by phone now. I know that some of the Superior Courts have done the same thing. I suspect that some of that will last. I suspect that simple hearings, which trial setting conferences, status conferences, things like that, may well last as virtual conferences. Obviously, jury trials, some other types of trials where you need to look at the witnesses, those are going to continue to be in person. But I think that the same thing that happened with us in our hearings will happen with Superior Courts, which is that there'll be many more virtual hearings now that everybody understands that it works just fine. And I think that's going to be a lasting change in, not just in this state, but not in just Los Angeles County or this state, but everywhere. I think people are doing a lot more things virtually, and that'll continue. Second question is, what lessons have I personally learned since the start of the pandemic and all that has happened in between? As far as the court system is concerned, it has been good things and bad things. We have had situations where people have hung up on certain litigants. We had one where a judge hung up on the litigants because he was angry with them. Unfortunately, it was one of my judges who I supervised. But we have other people who have had trouble with connecting with the technology and other things. There are certainly a learning curve, and so I will tell you that I've learned much more about technology as far as the communication aspects, the different types of conferencing systems than I knew before. I've also learned that I had to train my judges how to control hearings virtually. And certainly something I did before, but certainly now it's become far more important for me to train my judges to manage hearings remotely with tone of voice, with keeping people calm and different things to make sure that these hearings transition smoothly. We also have a backup system in place so that they have emergency numbers in case there are technical problems they can't resolve. That had to be set up and that had to be done. And so I've learned far more about those systems and how to train judges to manage hearings remotely than I did before the pandemic. And here's the third question. More frequently than most people are aware, there are instances where the safety of judges have been threatened. What would you like to see to ensure the safety of judges? One of our judges was actually beat into hospitalization while she was hearing a case by one of the litigants. So this is near and dear to my heart. I will tell you that I now analyze all of the hearings which go out to see whether or not there's any possibility of violence. I personally had a litigant attack a county worker when I was talking to them virtually over the hearing, and I had to get her off the county worker by remote Zoom, and that was a challenge. We have state police and we have sheriffs who come to our hearings and sit in the room. If I even think that there might be a problem, we've had them sit outside the door. Sometimes I put them in the rooms with the judges. It is critical for the service of justice that we have the judges feel safe. So I think that I would like to see those types of things continue. And I think that, the presiding judges like me need to be able to assess and continue to assess litigants for the possibility that they may be violent. That's certainly something that's required. How much time do I have left?
About 25 seconds.
Okay, I'll leave it there. Thank you.
Thank you. Next up, Karen Bracco.
Good evening.
Good evening.
I would agree with Mr. McKay. One of the biggest changes has been virtual. And I work in criminal, and at the beginning of the pandemic, it was essential so that we can continue working and handle cases to minimize the eventual backlog. I'm not a fan of virtual. It seems now that as we're hopefully moving out of the pandemic, attorneys are using it as more of a convenience than an essential. And oftentimes we have defendants who are in court without their attorney, and they may want to ask a question. No, you've got to ask your attorney, and they're standing there alone without any representation. And oftentimes being in court is the only time that they get to see and consult with their attorneys. So as much as it is a convenience when you have to have an appearance in another courthouse or you're in trial, it also does a disservice to the clients and the defendants. So over time, I'd like to see it subside. I had a case in Catalina where the attorney entered into an agreement for diversion. And when we came back 6 months later for the diversion progress report, he hadn't even informed his client of the deal. And I think that does a disservice where the client was never in court, he was never in court. So again, like I said, I'd like to see that subside over time. One of the things I personally learned over the course of the pandemic is patience. Oftentimes, because of our caseload, everything is quickly move to get through all of the cases. And when the pandemic hit, things came to a screeching halt. And as a part of my job as the special trials deputy dealing with murder victims' families, I had to explain to them why this case that was all of a sudden 2 years old, we're going to age it more because we're not doing any trials or court hearings to the open public. And it taught me a lot as far as patience and just slowing down and making sure people understand what's going on and that we're still trying to do the best for them, even though we may not be in court or they may not see what's going on. Given recent events, I think that judicial safety and independence is paramount. Judges are an independent body. We're not political, we're not partisan, we're independent of those types of things. And with recent events and people picketing or protesting out in front of judges' homes, it puts them at grave risk because we know how some protests can turn violent. And I think that judges' safety should be paramount, and not allowing protests or picketing in front of a judge's house because it ruins the independence. I was at an event over the weekend where people were asking direct questions of the candidates. How are you going to rule on this issue? And we had to explain to them that we can't. We have to decide cases when they come before us based on the merits of that case. And when people weren't getting the answers that they wanted, they got angry. And this was supposed to be an open, meet the candidates forum. And some people were yelling and angry that they couldn't get the answers that they wanted. And I think that type of behavior can lead to jeopardizing the safety of judges and their independence, which I think should be paramount. Thank you.
Thank you. Lloyd Handler.
Yes. Are we supposed to be talking about civil unrest impacts now, or just the pandemic impacts?
Both.
Okay. Well, just about the pandemic, I won't go over all the changes that have been observed already, but in terms of criminal practice, one benefit has been the jail has worked with the public defender's office and other offices to be able to place scheduled phone calls to clients in addition to video conferences. And I think that will be something that will be very helpful. And there would be no reason to discontinue that. And then again, it's very useful to be able to call in for minor appearances, and also hopefully they'll continue to allow defendants to appear through their counsel when they're not really needed. A lot of times clients.
Sorry, we lost you. I can't hear him.
Hello?
I think we have a bad connection. We can't hear you.
Can you hear me now?
Yes, we can.
Okay. A lot of times clients, it may be hard to fathom, but sometimes they just get sort of worn down, especially on minor cases where they're being offered probation with no jail time or some community service. And just taking time off work and having to get downtown or to some faraway court wears them down. And I think if they're allowed to continue to appear for hearings that are just going to be procedural in nature and not have anything important happen, that will be good for everyone and make things more fair and not have people pleading guilty to things just to have to stop coming to court. One of the lessons I've learned, though, is that the judiciary as a whole doesn't really care that much about the rest of the people. They had rules nominally in effect, but in many of our courthouses, including the one I work at downtown, the court did not allocate resources whatsoever to enforcing the rules in the public spaces. And so, although you had limits on people being in the courtroom, there were hundreds of people outside of the courtroom, many unmasked, and many of the most unmasked people tended to be police officers, and no one seemed to want to confront them or enforce the rules. Also, a lot of judges were too weak to even confront their own bailiff and require them to wear a mask even at the peak of the epidemic. So I think as a bench officer, if I become a judge, I'll be much more concerned about public safety for everyone because frankly, anyone who's gone to serve jury duty in one of our larger courthouses has been really literally risking their lives or the lives of their family, the way things have been allowed to go on. I'd like to talk a little bit about the social unrest aspects, though. We had a lot of people trying to legitimately protest, and a lot of people got arrested somewhat indiscriminately once looting started. And I think the system has to be very careful to be able to differentiate and take the time to differentiate between people who intentionally went to locations where there's protests with the idea of looting and taking advantage of the situation. And then those people, especially in minority communities who have experienced just lifetimes worth of microaggressions and sometimes very overt instances of racism to themselves or to people close to them, where when protesting, once things got out of control, they may have impulsively joined in. Those people are not as culpable as someone who organized some gang member friends to intentionally go to a neighborhood and loot. And I think that the system, including the judges, have to allow the parties to take the time to sort those people out, because given what society is going through in general, I think that someone who just got caught up, who didn't intentionally set out with the idea of committing a crime in the process of peacefully protesting, shouldn't necessarily have their life ruined by being saddled with a conviction if there's some sort of either lesser charge available or some sort of diversionary path available to them. So I think that's something we should keep in mind, as a lot of these people still have to come to court because their cases were delayed because of the pandemic. But when they come into court, I think we need to look at those cases individually and not apply some sort of wholesale solution or disposition to all. So
thank you.
You're welcome.
Okay. Troy Slaton.
Thank you, Ms. Bemis. So I'm an administrative law judge now, but I served in the Superior Court for the first 16, 17 years of my career. And the changes that I've seen with regard to the pandemic have been both a blessing and a curse. We've heard from the other people about the use of technology to allow remote appearances. So there has to be a differentiation made between civil and criminal proceedings. It could be very helpful for people in civil court to be able to appear and make quick appearances without the need for actually going to the courthouse. One of the major barriers to access to justice is money. And what used to cost an attorney or cost a litigant several hours for their attorney to drive to and from the courthouse can now be accomplished within a couple minutes with remote appearances. So I hope that the court maintains that, but Ms. Bracco brings up a very good point in that in the criminal justice system, if a defendant is going to be in court, they need to be there with their attorney. But if the defendant is not there, and in most cases, the defendant does not have to be there in misdemeanor matters, and even in some preliminary calendaring felony matters, the defendant doesn't have to be there if there's the proper waivers in place. In that case, it would make most sense and it would be most cost effective to allow attorneys and litigants to appear remotely. So I hope that the court continues to use that. And there's some additional technology that can be used as far as texting and other things to allow reminders, to allow the court system to remind people of court appearances. As when I was practicing as a defense attorney, I saw so many instances where people would forget or miscalendar a court date, and suddenly they've got a warrant for their arrest. And that is an undue burden on both the court system and potentially something very damaging for somebody when a simple text could have avoided that problem. Some lessons that I've learned since the start of the pandemic and all that's happened in between is the importance of interpersonal interaction. One of the things that trial lawyers rely on when conducting trials is the interaction with the jury. It's the voir dire process, the jury questioning. When trial attorneys are putting on their cases, both prosecuting cases and defending cases, it's so important to get facial reactions from witnesses and from jurors. So figuring out ways to allow that to happen while still ensuring the safety of the public and the participants is very important. Being able to read someone's face, being able to judge credibility. As a judge right now, as an administrative law judge, I rely on the ability to see someone's face. So sometimes maybe even seeing somebody on video versus having somebody in person who's wearing a mask may be a better situation. So I think judges are in a really good position to be able to judge and be able to coordinate their calendars where they can accomplish those goals. The rights of the defendant to be able to confront and cross-examine the witnesses, of civil litigants to be able to test their case and be able to judge credibility, I think is really important. And lastly, judge safety. Yes, we've seen with the recent news accounts of people protesting and threatening Supreme Court justices is really frightening and really eye-opening. We rely on, in the LA County Superior Court system, on the Sheriff's Department to provide the safety for all the participants in the courthouse, as well as judges. There's some specific things that are done to provide security for judges as far as masking their license plates, providing extra security when there's been a threat, escorts to and from their cars. But certainly, I think that there's some things that can be done as far as legislation locally and on the state level that would provide some extra protection for judges, as there is on the federal level. Federally, it's illegal to protest outside a courthouse or outside of a judge's residence in order to try and influence a case. So if people are doing that here in LA County to try and influence the outcome of a case by threatening a judge to try and get an outcome, that's a very serious thing that all of the people of the County of Los Angeles should be concerned about. I'm a judge now, sitting in Van Nuys, and I rely on the state police to provide the security. Thank you for the opportunity, and I'm happy to answer any other questions.
Thank you. Tim Rubin.
Okay, can you hear me now?
Yes.
Good. Good, good, good. Well, you've heard some excellent points by the other panelists here. I'm just going to pick up on the comment of Troy Slaton, and he's absolutely right that it's so critical for judges to be safe. And he's absolutely right that there's some great things that can be done. And we've seen these protests just recently against the Supreme Court justices. I should just make the comment that it is ironic. The Supreme Court justices do want their privacy. They do deserve their privacy, the ability to be left alone and to do their jobs. But of course, what is being protested, ironically, is about privacy, because a woman's right to choose is based on privacy. So it is ironic that the discomfort about privacy of Supreme Court justices is about what looks like a dismantling of a 50-year-old concept of privacy, which is frankly so important to our nation, both for the issues of abortion and many other related issues. So it's just an irony of the circumstances. Now, actually, on the topic of Zoom, I'm a huge supporter of the remote appearances. As has been suggested, it does cut down the costs of this. And I have done many cases on Zoom. I've taken dozens of depositions. We've done arbitrations. I've argued before the Court of Appeals. We've argued before the California Supreme Court, all remotely. Now it saves enormous amounts of money. It's much more convenient. And I think it's in many ways more effective in many of these circumstances. Now, my cases are almost all civil. So as a practical matter, I don't have the issue that was raised by one of the panelists about the importance of having direct communications with the criminal defendant. But as a practical matter, I'm married. My wife is a divorce lawyer. She doesn't leave home anymore because she can practice entirely out of her home and does all the court appearances, the client meetings, everything remotely. It's more convenient for people. It saves costs. It must continue. Now, there are some judges who fight against it, by the way. They want people to show up in their courtroom, I think because they're lonely. But as a practical matter, what should be happening is this Zoom and these remote appearances need to stay. Now, let's talk about the clogged up courts, because the pandemic caused clogged up courts and massive delays, and cases are backed up. And one of the big issues I have is about delay. Delay is a bad thing. Justice delayed is justice denied. So the importance, in my view, the impact of the pandemic is judges kicked things down the road because they couldn't handle the matters. Now we have a massive clog. In my race, if you vote for the judge who's leaving it, that'll leave an empty office. And we need to fill those offices with judges who will do the work and move the work along and get cases handled promptly and well. And so I'm hoping you'll take that into account as well. Thank you very much.
Thank you. Okay, I'm going to stop sharing my screen. And let me check, see what questions we have here for all of you. Okay, one question I have is, how will you protect the rights of folks to protest and directly challenge those in power? How about we go in the same order for about a minute, please. Clint Mckay.
Thank you. And the question again is how would we protect the rights of protesters?
The rights of folks to protest and directly challenge those in power.
How would we protect that?
Yes. How will you protect the rights of those folks?
I think that you have to give people the rights to protest to the greatest extent possible without other people safety being threatened. I think that it's an absolute fundamental part of our society to allow people to protest anything, no matter what side of the political spectrum they're on. And there may be more than two sides, but certainly these days there appear to be just two sides. But it is, I think that they have to have the extent to which they can protest is limited only by other people's safety being threatened. I don't think that what happened with the Supreme Court justices, from what I understand, they were peaceful protests. And the chalk, which was apparently outside Susan Collins' house, which greatly upset her, doesn't seem to be a problem for me. But I think that you need to really let people go to the maximum extent you can until people's safety is threatened. And I think you need to make sure people are safe, whether that requires police presence or not. That would be my response.
Thank you.
Yeah.
Karen Bracco.
I'm sorry, I know it was a two-part question. What was the second portion of the question?
So how will you protect the rights of folks to protest and directly challenge those in power? So it's really one, yeah.
And I agree with Mr. McKay, the right to protest is paramount. You have to allow people the ability to protest, but it has to be done in a safe and effective manner. Once they become violent or the looting occurs, the message is lost. So I think by having police presence or controlling the time, place, and manner of the protests, which allows them to safely protest and get their message across, is the way to protect their rights. With respect to the direct challenging authority, that's through protest and also at the ballot box. If you don't like the way the politicians are acting, you have the right at the ballot box to say your vote, say your voice, and in addition to protesting. But again, as long as it's done in a safe manner so that the message is not lost.
Thank you.
Thank you.
Mr. Handler. Did we lose him? Mr. Handler, you're on mute.
To just go with the second part, since we're just talking about that, time and time again, it's sort of like Groundhog's Day, there's a big public protest and our local law enforcement
We're not able to hear you. Sorry, Mr. Handler, we can't hear you.
Sorry about that. They end up injuring people. They end up violating people's rights. And obviously, as a judge, you can't control that. However, if there are cases involving either people civil or seeking injunctions or bringing lawsuits civilly at the back end, or in a rare case where the district attorney or city attorney might file cases relating to misconduct, I think a judge has to be, one of the solutions is for a judge to be even-handed and hold the police to essentially the same standard of conduct that you would one of the protesters are.
Thank you. Mr. Slaton?
The right to protest is paramount in our country. The right to let those in power know that what they're doing is wrong, or that a policy is wrong, to seek redress of your grievances. That's goes back to the founding of our country. So the right to protest is so important, needs to be protected by law enforcement. They need to protect the rights of protesters, but also the right of people to be safe. When a protest turns violent, obviously, well, I'm hearing some feedback from.
May I ask everyone to go on mute if you're not speaking, please? Thank you.
Lloyd, can you put yours on mute, please? Thanks. Anyhow,
Go ahead.
yeah. So the right to protest is paramount. Obviously, we rely on police and law enforcement to protect health and safety, but that shouldn't be at the expense of allowing people to let their voices be heard. And I agree with Ms. Bracco that the best way to do that is at the ballot box. But people should also be allowed to scream from the town square if that's what they want to do. And people should be able to protest as long as they're not causing harm to their fellow citizens.
Thank you. Mr. Rubin?
Well, some great comments have been made, but let's remember who we are. We're judges, hopefully. That's what we're looking for. And the task of a judge is to listen to the facts and know the law and make decisions before him. So the topic of protesting and how do you give rights to the protesters is something that I've litigated myself. And I'm actually an expert in the area of what's called anti-SLAPP law. That is against people who protest. Sometimes people initiate, to stop the protesting, lawsuits to create enormous burdens on them. So as an expert in that area, what I've done in the past is I've gone in and brought motions before the court to stop these kinds of lawsuits that will sometimes intimidate protesters or create extreme cost for people who are trying to communicate their ideas. Now, you have to know about this law in order to properly adjudicate it. And many of our current bench officers are not that familiar with the area of the law. I am. So when confronted with the reality of something in front of me about the right to protest, I will know the law and I will enforce the law. And the law does provide that people who peacefully and properly protest have a right to do so. And I will give sanctions against them, which is allowed under this particular law, against those who try to use the system to impede the rights of people to exercise their right of First Amendment free speech. Thank you.
Thank you very much. And I want to thank all of you for participating. As mentioned at the beginning of this has all been recorded and it will be available. So please send anyone you'd like to the League of Women Voters site. We'll send that to you and people will be able to watch. So I think they're asking us to leave now and head back to the main room. So thank you very much.
Welcome back, everyone. I hope everyone was able to get a lot out of tonight's program. And on behalf of the Junior League of Long Beach and the League of Women Voters, we'd like to thank you for attending tonight's forum and learning more about the judicial candidates. We will follow up with all of the attendees via email with the linked videos of tonight's forum when they are posted and made available to the public. Please feel free to share with your friends, family, and professional networks. I'd also like to give a special thanks to all of our judicial candidates tonight for joining. And I hope you found this to be fruitful. I know there's not a lot of these types of forums for judicial candidates. And so we're very excited that you were all able to join us. Please follow us on social media. You can visit jllb.org to learn more about the Junior League of Long Beach and lwv.org to learn more about the League of Women Voters. And again, thank you all so much for attending. We hope you have a wonderful evening.
Candidate is going to have 4.5 minutes. So Ms. Anna Slotki Ratano, please begin. Your time will begin now.
So I have experience with the collaborative courts. I actually just got a client into women's reentry, as well as drug court. I worked in the drug court and juvenile court at Eastlake Juvenile. My favorite option, however, is diversion. In the collaborative courts, the way it works is you plead, so you admit the charge, but you get sent to a court that keeps tabs on you a little bit closer. So you keep checking in with the court and they monitor your progress, make sure you're being held accountable, that you're sticking with the program. But you have a charge. The difference between the collaborative courts and diversion is quite simply that the opportunity, you have an opportunity to never get convicted when you're diverted. So that means if the defendant complies with treatment and doesn't reoffend, instead of having to plead or go to trial, it just gets completely dismissed. So they don't have anything on their record. This means that they don't have issues, regarding employment, school financial aid, which actually is a problem, and other issues or barriers that come up when one is convicted of a felony or facing felony charges. Diversion is what it sounds like. So instead of admitting a charge, what happens is you have, as a defense attorney, I would have to write a motion saying that the defendant has a mental health related issue that led to the offense, that it caused the offense, and that there are treatments available that the defendant would benefit from, and that he'd be amenable to treatment. So usually a lot of work goes into just getting that motion written. What the defense attorney has to do is you have to appoint a psychologist to evaluate the client. I mean, you have to know that there's a mental health issue to begin with. And then, that takes time. Then the psychologist gives me the report recommending a certain kind of treatment. Then I have to find the program that will make that treatment work for the client. So for example, I had a client who was recently diagnosed as bipolar, and he picked up a case when he was having a manic episode. The doctor recommended that he regularly see a psychiatrist for medication, a therapist to deal with, he was a victim in a crime, so to deal with the trauma from that. And there was a theory that that's what triggered the manic episode. So I had to find the therapist, and it's hard to find one that's low cost or free. So I ended up having to get a social worker to help my client get the right paperwork together to get insurance to cover the costs through the state. I got him appointments, letters from the doctor, and I ended up having to show the judge that we'd met all these things. So the judge felt confident in granting the diversion. The reality is most felonies are not serious. A lot of them are pretty low level. And what I've been seeing a lot is mental health. Most of my clients are mentally ill, and I think that needs attention. So, I had one client with a history of schizophrenia. He's young, maybe almost 30, but back when he had his first episode in his early 20s, he wandered into a garage because a voice told him he needed to be there. He was found in the garage, arrested for burglary, and then he ended up pleading to a strike to get out of custody right away, right? So now he's got a strike on his record. And several years later, he picks up a case that was a result of a psychotic episode. He has to go to jail. However, mental health diversion is going to allow him to get the treatment that he needs to get back on track, not go to prison and then get released without any, options, programs, or help. And ultimately, he's going to be able to succeed rather than fail because of, 2 incidents that resulted from his mental health problems. Sorry, I didn't see the timer, so can you, I can't hear you.
Sorry, you have about 10 seconds.
Oh, sorry. Oh, I kind of just wasted it. But ultimately, I do think that diversion is a really useful tool if we want to help people get back on track and not have them continue through this revolving door of prison and then just releasing them with nothing. Like, we can help people and prevent future crime through that using diversion.
Thank you. Thank you very much. And we're just working out the bugs here. I hope you have patience with me. And now we are going to move on to Sharon Ransom.
Hi, can you hear me?
Yes.
Okay, thank you. So I am a deputy district attorney and I'm assigned to the mental health psychiatric unit. I handle 50 to 60 cases a day regarding competence, whether a person is competent to stand trial, whether they get mental health diversion as well as others. I've previously been in or had people that went to Veterans Court and drug court. I staffed a drug court a long time ago. And I had a case where a guy was referred to Veterans Court. He attempted to strangle his mother because he thought she owed him $2 million and she only gave him $100. Just before the preliminary hearing, the mother came to me and expressed concerns about her son's mental health. And this was not known to us. So what usually happens is we don't talk to the defendants. The defense attorneys, the public defenders talk to the defendants. We can't talk to them. So if we find out about their mental illness or whatever problem they're having, it has to be brought to us by the defense attorneys. In this case, the mother brought it to our attention, and I worked with the defense attorney to get him into a program. The problem was he was Korean speaking. Although he had been a veteran, he chose not to use his English to do the program. So ultimately, we were able to find him a program through the Veterans Court, and it was successful. He needed medication. His mother did not want to come to us and tell us this, but it's good she did. So in mental health, we do have diversion, and there has to be a certain criteria that has to be met. One, the person has to suffer from a mental disorder. The mental disorder has to be a significant factor in them committing their offense. The symptoms have to respond to mental health treatment, and the person has to consent to going through the diversion program. And finally, there must not be a risk to public safety. So we're balancing all of those issues to make sure that people that do suffer from mental illness are able to be diverted. And I've seen some successes and I've seen some failures. One of the things is a person has to be willing to go through it. We can put them, so if they're sentenced or they need to be put in a state hospital, there's a 6 to 8 month wait list to go into a state hospital. But we have programs in the community where they can go to a treatment program, get their treatment. And we had a guy last week that was just so excited because this was the first time in 20 years that he had a bed and a shower. And he went along with the program. We have people that leave the program because they don't want to do it. And I think that when a person is really willing to do it, it works for them. Victims, in my cases, when I have a victim that's been a victim of a crime, I reach out to them and I let them know. And a lot of times the victims know, just based on the facts of the crime, that this person has some mental health issue. And I explain to them what's going to happen and that this person needs the help. And normally they go along with it. And a lot of times the victims are family members because that is who a mentally ill person usually is around most of the time. So it works out in that instance. Some of the drawbacks are, some people say they get access to more drugs in the programs than they do on the street, more access to alcohol. So those programs need to really be monitored. And so the people can have success at diversion or collaborative court efforts. Mental health, it is a collaborative court effort. We work every day with defense attorneys, DAs, doctors, psychologists, psychiatrists, the judge, social workers, court staff to make sure that these collaborative efforts are successful. We work together as a team, and we can't not put someone in prison that is mentally ill. So we work at trying to get them treatment and trying to get them better. And I think it's really one of the greatest programs. Thank you. I think it's one of the greatest programs because we are helping and we are treating the illnesses of a person and making sure that they are better to be in society and make a better society. And I thank you for your time and for listening.
There we go. Okay, thank you very much. Holly Hancock, please.
Thank you. My experience with diversion and collaborative courts is ongoing, but as a trial attorney, and that was for 14 years, I often sought to, and I can handle all kinds of cases and they don't all go to trial. It just means that you can work up your case to trial. So I have handled mental health diversion cases. I've handled cases that were, for many years, diversion was not an option. So my opinion about this is that this is going to be the future. The courts are going to create more courts that deal with the mental health issues. Los Angeles County has the largest mental health facility housed within the jail system, you know, in our county and in the state. So, and I may venture to say the country, because it's very large. The people who are being assisted there, really, who are being held there, really need to be in some kind of mental health program. As one of the other candidates stated, sometimes they're not competent, so we can't proceed forward. But where they are held is in jail, and during that time they may not be getting any assistance, and so there's a problem here, a gap in time, a lack of resources. And one of the drawbacks, the biggest drawback, is a lack of funding for any of these programs. I am currently the deputy in charge of the homeless mobile unit, and it's the collaborative court that is for those who are unhoused. Many of those unhoused people are mentally ill. It is a diversionary court. There are only 2 right now in the county, one in Redondo Beach for Torrance and one in Long Beach here. And it works really well when we do get the money to do it, because you have different services that come to the court, and we do expungements. So my unit does the expungements for the other cases, so that the client can get into housing when they are done with whatever the cases they're done. They see, you know, counselors, they take their medication, they get sometimes job training, etc., so that they can move forward and get into housing and be independent. And I think that is a huge benefit, that if you can create something with wraparound services. Currently, my office and my unit and me, I'm trying to get a homeless court set up downtown, because it's really needed down there as well. But again, we have the money issues. This is something that the Judicial Council must agree to. And so that is something that judges can work toward having more of. I think we're going to have more of them. We're not just going to have homeless and veterans. I've also worked in drug court. That was a post-plea court. I have a problem with that, because it still leaves the conviction on the record, and then they have to come to me or somebody, or a unit like mine, to get it expunged, but they will not do prison. However, drug court in Los Angeles County, you start in a unit that's within the jail. So there's an actual jail unit that starts the process of, you know, Narcotics Anonymous, etc. And they detox there. So it's still a problem, because they're still in jail, and that's kind of like the problem that I have. Yes, the problem that I have with balancing defendants' rights versus perhaps the community's rights. I think we do want the community to be safe, and these courts assist the community in being safe, because we get to the root cause. Again, the defense attorneys the public defenders have to identify the problem, and we have to bring it forward. And I think it's the wave of the future, and it will be happening. We just got to get the money.
Okay. Thank you very much. And we are moving to, I believe Randy Fudge is next. Thank you.
Okay, thank you. As I indicated before, I run the day-to-day operations in the 3rd largest prosecuting agency in Los Angeles County. We are also a nationwide leader in diversion and offering defendants alternate sentencing, including drug and mental health treatment, housing, and job assistance in lieu of prosecution and/or jail time or fines. I've implemented multiple programs in my office to assist youthful offenders and persons suffering from homelessness, substance abuse, and mental illness. Our PATH program, for example, targets young adults 18 to 24 years old, and research has shown that these people whose brain are still growing and that these people often make poor decisions. In appropriate cases, youthful offenders accused of misdemeanors are offered the choice of completing occupational training, mentoring, or educational programs where, for example, they obtain one-on-one counseling for job skills and how to make a resume in lieu of criminal prosecution. Many people who have participated in this program went on to obtain additional education, internships, and even employment in lieu of criminal prosecution. We've also instituted a priority diversion access diversion program, which allows people suffering from mental illness and substance abuse to obtain treatment in lieu of criminal prosecution. We work with LACADA, that's the Los Angeles Centers for Alcohol and Drug Abuse, and we were able to provide live-in treatment for misdemeanor defendants whose minor crimes are primarily the result of mental health or substance abuse issues. Through collaboration with the court, defendants with mental health or substance abuse issues have been able to obtain this live-in treatment instead of jail time, and we have social workers in the courthouse who are able to facilitate their transfer from the jail to the live-in treatment program. In fact, I think we may be one of the only prosecuting agencies that have a full-time social worker on our staff. We've also instituted a community service worker program, which allows people who are convicted of crimes to perform community service in lieu of jail time. Similar to Caltrans, this allows people who've committed crimes in Long Beach to do community service in Long Beach in the parks, wetlands, in addition, and this benefits the city. And they also receive informative lectures and they learn something about nature and the importance of preserving these areas. Our office has also instituted a homeless court program, which assists people experiencing homelessness to take care of outstanding criminal cases and help people with such services such as housing, disability benefits, mental health, and substance abuse counseling. Los Angeles County Supervisor Janice Hahn is a great supporter of this program and has helped us to obtain funding. The benefits of these diversion programs is significant. Currently, due to jail overcrowding, defendants in Los Angeles County who are sentenced to 100 days or less are immediately released from custody and receive no jail time. Not only is jail a minimal deterrence, but it does not solve the root cause. Our diversion programs, which seek to address crimes caused by youthful indiscretion, homelessness, substance abuse, and mental illness, have proven to be very successful and are being adopted by other agencies. Justice requires a balancing of the victim's rights and the defendant's rights. A system that does not seek to address the cause of crime and provides no consequences for violations of crime helps neither the victim nor the defendant. Our diversion programs seek to help address the cause, be it education, mental illness, substance abuse, as well as provide a consequence in the form of additional prosecution and incarceration.
30 seconds.
When properly administered, diversion is a win-win for both the defendant and the victim. And when properly administered, diversion can help all parties involved and can be a great tool.
Okay. Thank you very much. Ms. Georgia Huerta, please.
Yes. Hopefully everyone can hear me. When I was working with the district attorney office between 2018 and 2021, when I left last year, I was working in the community collaborative court. And at that time, there were 4 community collaborative courts within the LA County area. Now there are different other courts that, homeless courts, different other types of courts that have sprung up after that. But I'm going to talk about the community collaborative court, also known as the alternative sentencing court, because they're still here and working in full force. First of all, I would like to say that when you balance the rights of the victim and the rights of the defendant in these particular cases, I think both sides is a win-win. The majority of the time, the victim is a family member, and a family member wants their family member to get help and to get aid. So they're not in opposition to it. If the victim is not a family member, then we have other types of actions that we can take to keep the victim and the defendants apart, such as a restraining order or a stay away order or a protective order. So that's in balancing the rights of the victim and the defendant. Secondly, whether or not these particular programs or this particular program is a benefit or a drawback. After working in that unit for over 3 years, it's definitely a benefit. The purpose of the program is to stop the revolving door of homeless people, people suffering from substance abuse, mental illness, veterans, at-risk youth, and sex trafficked individuals. They really have no place in the criminal justice system. So this program is designed to address their needs, the root cause of the problem, to get them completely out of the system. Sometimes it's looked upon, well, it's as social working, but it really isn't social working. It's helping those people that really needs to be helped and to get them out of the criminal justice system where they do not need to be in the first place. Also, in our community collaborative court, when an individual successfully completes the program, their case, even though they have to plead to get into the program, their case is dismissed under Penal Code Section 1203.4. And also their record is expunged. Any benefits that the defendant receives in our program, they do not have to pay for them, and those benefits are given to them. The biggest plus of the community collaborative court is accountability. And when I say accountability, not only accountability for the defendant to do what is required of him or her to be in the program, but also the programs that are offering the services, they are accountable to make sure that the defendant receives those services. All too often, defendants are just given medication and just left to figure it out on their own. Well, that's not the purpose of the community collaborative court. Once every month, they would come into court. They would tell the judge how well they were doing. If there was a problem with them getting their medication or with the program, then a representative from the program was required to come into court and explain to the judge why that particular defendant was not having their needs met as ordered by the court. And it's amazing that when people are held accountable, they actually do what it is that they are ordered to do and what they say they would do. And that's exactly how this particular program worked. Yes, it required the defendant to come to court, but I believe once a month, but I believe that that gave the defendant a basis to know that someone was concerned about them, that they were getting the housing that they needed, that they were getting the medication that they needed. And if they were not getting those things, then there was a judge there to make sure that they did. So I believe as well that the community collaborative court and these diversion courts is the way of the future for nonviolent, non-serious defendants. There needs to be an alternative other than jail. Treatment and rehabilitation as to those types of crime is a must. That's the only way we're going to get rid of overpopulation of our jails, putting people in jail that really should not be in jail. So I think it's an awesome program. Thank you.
Okay, thank you very much. And Patrick Hare, please.
Thank you so much. I want to start with 2 observations and then share a story if there's time. First off, in the over 30 years that I've practiced law, civil and criminal, ranging from conservatorship court, dependency court, as well as a criminal court, I have been struck by the overwhelming number of individuals in the system who have been affected by the traumas of homelessness, of substance abuse, of mental illness. It really is astounding. And for too long, we've had a punitive model, punishment over treatment, and people have been placed into the county jails, the prison system, where there is not adequate treatment. And they are released at the end of it, further traumatized by their experience without the needed treatment and training for them to function successfully
when they are released. They don't have the stability, they don't have the job, they haven't made the sorts of decisions that one makes in the treatment process to make the changes that we need them to make in order to function well in society when they are released. The second observation I want to make is that for too long in this country, the judicial system has been running on the narrative of the adversarial model, which for so many of these cases is not an effective way to approach them. In the adversarial model, we have winners and we have losers. If a defendant goes to trial and is found with defendant with mental health or substance abuse issues, homelessness issue, goes to trial and is acquitted, they're back out on the street with no changes. If they are convicted, they're often sent to prison, where, as I mentioned, they don't get the treatment. Occasionally, you'll have a judge that's willing to give them a chance, places them on probation, but if they slip up and fall, and if you've ever been in recovery or know people that are active in recovery, you realize that relapse is part of recovery. But so few judges understand that. They feel that they gave the person an opportunity, they failed, and they're sent off to prison. And so there's been a new model lately, moving away from the adversarial process, win-lose, to the collaborative process, win-win, which I believe is a much more promising way forward to deal with the issues of crime in our community in a way that truly leads to community safety. I've worked extensively in my career in the collaborative courts. I worked with the HALO program with the city attorney's office, homeless alternatives to living on the street. I've worked with the women's reentry program, the veterans court, and in felonies, I've worked with the Office of Diversion and Reentry, as well as the Rapid Diversion program. And I can tell you, based on my experience, that there's a very, very high success rate, much higher than the quote unquote success rate of people coming out of prison. And one story to illustrate that point. Several years ago, I received a case on my desk of a young woman with no prior criminal record who was charged with a serious felony, residential burglary, breaking in to someone's home with the intent to steal. She had been wandering around. She climbed through the window into a condominium complex, and instead of engaging the sort of behaviors you would expect a burglar to engage in, she didn't take the jewelry, she didn't take the computer, she helped herself to a sandwich and a soda in the kitchen and sat down on the couch. And when the neighbors notified the owner, he came home and there she was eating a sandwich. Well, because she had technically stolen something while she was in the house, the filing deputy of the district attorney, who didn't have enough information, filed her with a serious felony. But I was able to get her mental health records, and collaborating with the court and the district attorney, we were able to get her into mental health diversion, and her case was dismissed. So I'm a testimony to the fact that everyone working together, DAs, courts, mental health, can truly have success stories and create true community safety.
Thank you very much. Right on schedule. Let's see. I don't see any questions from the chat. I'm not sure that we actually got any questions for you. We have less than 1 minute to go. I think, Anna, I think I shorted you by about 20 seconds. Do you have any final comments you want to make?
Well, I just wanted to say that, you know, the problems that I've been seeing with diversion is that there's a lot of judges who don't agree with it. And judges have the discretion to grant mental health diversion. It doesn't have to be something that the DA agrees with. But what I've been seeing is that when, you know, when you're a hammer, everything's a nail. And I think when you spent your career putting people away for the max amount of time, I think that it's hard to unlearn that and get off that foundation and go along with a program that doesn't involve prison. So I've been seeing a lot of resistance to that on the bench, and I'm glad that the other candidates are open to it, but it's important to get more judges on the bench that are willing to, you know, use diversion.
Great. Thank you so much. I really appreciate all of your comments. This was a fabulous session, and we are going now to go back to the main room.
Welcome back, everyone. I hope everyone was able to get a lot out of tonight's program. And on behalf of the Junior League of Long Beach and the League of Women Voters, we'd like to thank you for attending tonight's forum and learning more about the judicial candidates. We will follow up with all of the attendees via email with the linked videos of tonight's forum when they are posted and made available to the public. Please feel free to share with your friends, family, and professional networks. I'd also like to give a special thanks to all of our judicial candidates tonight for joining, and I hope you found this to be fruitful. I know there's not a lot of these types of forums for judicial candidates, and so we're very excited that you were all able to join us. Please follow us on social media. You can visit jllb.org to learn more about the Junior League of Long Beach and lwv.org to learn more about the League of Women Voters. And again, thank you all so much for attending. We hope you have a wonderful evening.